And your Lordship said that it is adjourned to 4th. You move an application before the trial court.
Yes.
Now, I moved an application, my lords.
Yes.
What the trial court says is that no, this is getting delayed here. So he has fixed it to 24th February. My learned friend here is there. He is on VC. So we have agreed for 6th. And what I want is, my lords, a small order that he will extend it. He will not hear it on 24th. If your Lordship order to 290. Your Lordship may see this.
Yes, Mr. Naik, what do you say?
Your Lordship, let it be listed on 6th and no further adjournment should be granted after 6th.
Yes.
That's all right. But my trouble
But
is...
at 24th, the matter is there.
But
See,
the trial court should not have done that. It is...
Yes.
Yes.
24th at least.
Yes, Your Lordship.
But
But after 6th, Your Lordship, no further adjournment should be given because Your Lordship...
Yes, I'll indicate that.
Yes.
Mr. Purijan, shall I pass an order or just...
No,
Yes.
May I say this? Since the matter is not in the list today, your Lordship may call it tomorrow and pass an order. That will be more proper.
What do you say? Let me
Whatever Your Lordship will be.
Because without the file being there...
Just observe that again the matter will be listed on 6th.
Yes.
No further adjournment will be
Correct. No difficulty.
You argue
Your Lordship actually fixed it on 6th at 2 p.m.
No. Today also, Your Lordship can pass an order. There is no problem. Why it should be listed?
No, there is no file.
There is a problem in our system here. Without the file being there, then...
Yes.
Okay. I'll pass the order.
Yes, Your Lordship. Yes.
I'll pass the order. 24th the date is there.
Your Lordship may then put a special notice outside that will be taken up at 2 p.m. because otherwise there will be some code. Yes.
Okay.
Grateful.
I'll just pass it for
Yes.
Your Lordship is taking about 2 p.m.
Just to pass a formal order on 24th, he will ask for an adjournment. It will be adjourned. And on 6th, the matter is listed, and it is made clear that no further adjournment shall be there.
6th, 2 p.m. So they will be taken.
Yes, Your Lordship.
1 minute.
Weekly list 72 items which could not reach yesterday. My lord, it's a very serious matter. The claimant is bedridden, quadriplegic.
I'll just see 72 what can be done.
Yes, my lord. My lord has already heard argument. We have also filed our note of arguments. My lord, we may take it any time after 3:30 or...
I'll just see
today.
how the board moves. Let us see.
I beg pardon.
Yes, 1 minute. Just take it up. Leaks these matters.
I may be pardoned to mention, Your Lordship.
Yes.
Your Lordship, this is a criminal appeal of 2009. This matter has been pending since 2009. And all of the co-accused have been died and only one accused is surviving. Now the accused have reached the age of 77. Kindly accommodate any date for the hearing, Your Lordship.
As there in the list.
It was there in the list. Today it was not there in the list.
Have you prepared the written note of submission?
Yes, Your Lordship.
See, when I was calling people to argue, nobody came. And now the board is so heavy and everybody is asking, hear me. That's the whole difficulty. And when I'll take it up, I am sure that again the matter will be.
Only I'll be taking 10 to 15 minutes.
Prepare a written note of argument.
Yes, Your Lordship.
And take from the pen drive, you take whatever documents are there.
Yes.
You come
Yes.
on the first week of let it be 3rd, 4th.
So 5th would be better.
Okay, 5th at 3:30, but no adjournment will be granted.
Yes, Your Lordship. Obliged.
Yes. 72, I'll take it up, sir.
Well, there are a batch of matters heard on 14th February relating to that FIR filed for economic.
Yes.
One of the matters is not shown in the order list at all. I think some kind of
Let's see that the group matters.
fresh matter also has been posted to another date. Same council, same matter, same FIR.
Give that with the
Yes.
take it up. Give that. That the group matter. That investigation. Just see how it is detagged, then it should have been.
I'm giving both the, along with the
We'll get this. There may be some problem in the office.
obliged matters. And it's also noting that will be taken up at 2 p.m. because councils are.
See, the 2 p.m. business
All
is
right.
making so difficult.
All
You know, if one matter is stuck, then the entire board is, getting. So therefore,
Obliged matters.
we'll see. Right.
Great.
I want to mention my lord, tied up bail matter. Filed a IA for interim bail
See,
matter.
tied up bail matter again, the problem is after the Supreme Court judgment, it may go to the
Filed a IA for
assignment.
interim bail, my lord.
That's right. You give it, but it may go to the assigned bench. Okay, you give it, we'll see.
Pardon, Your Lordship.
Yes.
It is regarding release of money. This was in the Lordship board on 6th and Your Lordship specifically directed to be listed on 10th of February, Your Lordship, but could not be listed. This is the money
which has been seized since 2022, Your Lordship.
I thought I have asked them to get some.
Two adjournments
Mr.
were
Das,
given to
Mr. Das,
State
vigilance.
Council to take instructions.
It is vigilance matter?
No, no, no. This is
State matter.
state matter.
तो देखो यार देखो मिनट कर
Pardon to mention.
Release of money, Your Lordship. 4 matters tagged
It's
off.
not very urgent.
Since 22, Your Lordship.
All right.
One criminal
People are languishing in jail, you want money.
No, no. It's regarding Your Lordship. They have not filed any charge sheet, Your Lordship. It was in the list, Your Lordship.
See,
And
let's see.
Lordship specifically directed it to be listed on
See
10th
how
February.
how can it be accommodated? Yes, sir.
criminal, that is year of 2009. That is
The same thing the young lady was now mentioning. The same thing. You get ready with the written note and all.
Ready.
I'll take up.
I submitted argument note before your lordship court and argue the matter. Very prepared.
In the first week onwards, I'll start hearing the appeal.
Previously it was listed, but it has not been listed. That is.
So therefore, in the first week of March onwards, I'll try to hear the appeals after 3 o'clock.
CBI matter.
Yes, yes.
I may pardon, my lord. I stand similar to my friend who was earlier mentioning. I have filed an IA for interim bail, my lord. Tied up bail.
Give whether it comes to.
Hello, Belgium.
Bless.
To save it. Restoration. I had already mentioned once. Yes, right of that is not been listed.
This is a phrase matter specific urgent.
Yes. Yes, start.
Any mention for item number 1 to 2?
My lord. Item 2, Your Lordship.
I pray my learned senior is there for the opposite party. We have tried to sort out this dispute. Not we. The Lordship may call it after first week of March any date. Will.
Are you going to do continue?
I will help everyone.
No. Okay, please sit for hearing. Okay.
The interim order may
Interim
continue.
order to continue.
Obliged.
Item 3 to 13.
My lord, item number 11, on behalf of Mr. Maharaj. He is not today in the station because his maternal uncle died.
Okay. On behalf of Mr. P.K. Maharaj, there is a request for
Next,
personal ground. Please the matter.
2 more paying koitha.
We'll just see.
My lord.
Yes.
14, 24.
24 also.
20?
4 also.
24 also. Okay.
Obliged.
Same, huh? Mr. Maharaj. Yes.
25, 26.
26 and 27 matters.
26.
26, I have informed other council, both the seniors will be rushing for it being lost. And this get now, I got the records and all this, and I'll just verify them. I'll come back to lordship within 1 2 days.
Have you told the other side?
Yeah, I've been informed.
My lord, I am
You have
appealing
informed?
item 26, your lordship.
Okay, 26, 27 on the request of
Next week, my
Mr. Das. See the date, how will it? Yes,
20 in 26, I interim order is there. Let it be.
entry mode to continue.
37 to 45. 46 to 51.
My lord, item number 50, my lord. In this case, without impleting the informant, I have filed the case, my lord.
50.
50, my lord. I may be permitted to withdraw the case for filing a better case, my lord.
Okay, let council petitioner seeks to withdraw the petition to file a better one with all particulars and documents. Yes.
Obliged.
Same page item 47. I have filed an withdrawal memo, your lordship. That is on record. I may be permitted to withdraw the case.
47 also withdraw. Huh?
The memo is on record, your lordship.
Yes.
52, 57.
Item 60, my lord. Mediation failed, my lord. Your lordship may keep it any other day for hearing this matter, my lord.
Who is appearing for the other side?
State and another private party is also there.
Have you informed him?
I will inform, my lord. I will
No,
inform.
then he'll come and shout. That's the problem.
No, it's-
First you inform, then he'll come and
My lord, there are series of cases with
That's right, but have you told then now?
civil litigation. I will inform, my lord. My phone.
Oh,
They have taken an adjournment. I will tell.
council for 61.
60, only 60.
60. Okay. 60.
What a 17 case ଅଛି.
Okay.
Counter case,
On the
civil
request of
dispute.
Counsel for the
There is no interim order.
counsel for the petitioner, and he undertakes to intimate the opposite side. Yes. 60. Yes.
Cannot.
60, 68.
Item 68, there are 2 matters.
Yes.
One, I have filed a 482 challenging 498 approach. The other side has filed a
Yes, 457%.
So my only saying is my 498 may be detailed from his application. That's about all.
My lord, in this case, the opposite, who is the opposite party number 2 is petitioner in my senior
So how
case.
does it matter?
But
How does
he
it
is not receiving the notice.
No, I'm
Make a perm-
appearing today in that other case.
He's entering if
Your lordship may only detail my
Yes, yes.
498. That's all.
No.
entering.
No,
So then the second matter is regarding what?
Second matter is,
457.
my lord, I am challenging a 498A proceeding.
No, in the second matter.
Second matter.
Yes.
I only want that number is 758 of 2024.
Okay, what is the first matter then?
The first matter is the 457. For
Release
return
of what?
Return of ornaments. etc.
Ornaments and all.
That can go on its own way.
And interestingly, the party.
Not interestingly, it is.
He is
They are both the same.
appearing.
Yes. So he is appearing today.
Appearing.
In the other matter.
So may I propose,
Hmm.
subject to my senior, if this matter may go for mediation?
No. Let my 498 let everything be separated. Not required.
498 matter,
Yes.
it is the submission made by the petitioner.
I am not saying anything. I am only saying my 498A, my
Okay,
758. That's all I am saying.
CRLMC 758 of 2024, DTAG release the matter for hearing.
And will not.
And insofar as the
I am entering at my learned friend is entering appearance today.
465324 is concerned. So to enter appearance for
Mr. Pranay Das.
number 2 and release the matter for hearing.
Yes, grateful.
And so far, my lord, IA notice was last occasion, lordship was pleased to issue. I may be permitted to file an adjournment application if required in the trial.
No,
court.
let it come next week. We'll see.
Oh,
No, that
28th.
lordship
28th.
may permit me
No,
to file an
28th, there is an opposition, otherwise I would have done.
28th, I'm not there.
Huh?
Other than
Any side, this side.
First March, first week of March.
First week of March.
first week of March could be the period. No? March first week.
But my lord,
But
kindly-
fifth or sixth,
If there is an opposition, I'll have to hear.
I-
5th and 6th, any day.
Sixth.
Because-
Sixth.
because there is IA is pending live work.
That's right, but there is an opposition, then I wait,
We will
then
see.
mentioning the Coriperiwin, na?
Otherwise, I will be benefited out of his order because my order is that adjournment application.
See,
not-
the
Yes,
four-
I understand.
498 matter, you should settle the dispute. Unnecessary.
Mallet 63.
Yes, sir.
May I pray for next week?
Okay, on the request of. Huh? Opposite party, but you please tell him,
Mallet.
opposite party. Yeah?
69 to 75. 76 to 80.
Pardon to make a mention, Your Lordship. Item 79 of the board, Your Lordship.
Yes.
Your Lordship, it is a hearing matter. The written note of submission along with the memo of citation has already been submitted before Your Lordship.
What do you want?
If Your Lordship could take up the matter at 3:30 today or as the last matter, Your Lordship.
It will be taken up. Why do you worry? It will be
Your
taken up.
Lordship, since it's a
Yes.
hearing matter, Your Lordship, that is why.
Yes. Next.
May I disturb your lordship?
Yes.
I missed the list. 60. Yeah, next week.
Already a junior have done the job.
Lordship, maintenance amount is stayed by your lordship. Maintenance amount, lordship. I will pay the tension matter.
Yes.
Item 1.
Item 1. Yes.
4 matters.
4 matters.
Yes.
Okay.
Out of 4 matters, first CRLMC, that is 1088.
Yes.
They were challenging the rejection of 205 applications.
Okay.
And subsequent 2 matters, one of the accused, there are 3 accused. I am appealing for one of the accused. I have filed a 482 application for quashing the proceeding. And my learned senior also filed a 482 application for quashing proceeding in respect to another co-accused. And last matter is challenging rejection of 205.
Then there are 2 applications for 205, 2 for quashing
Quashing.
by 2 different accused.
No, one accused, 205 rejection because
I know, but there are 2 accused. They filed 2 482s for quashing.
Yes.
And 205 rejection is also.
I have filed 2.
Yes. Let us come to the quashing. If it is quashed, then 205 is not required.
No.
Let us concentrate in quashing. If you have a case or not.
In respect of subsequent criminal proceedings concerned, first case is first proceeding where cognizance has been taken under section 285 and 304A. Both the offences are bailable in nature. Earlier, I had approached this honorable court. This honorable court set aside the order passed by the learned magistrate, remitted back to the learned magistrate for consideration. Again, that application rejected.
205.
First application, yes, 205 application.
Yes.
Both the offences are bailable in nature, and summons was issued. I appeared and filed a 205 application. And the lady, married lady.
Where is the quashing petition?
Quashing subsequent application is quashing.
Which one?
That
2548.
Yes.
2548, Mr. Mahapatra is appearing. You are appearing in which one? This must be 2565.
Yes, 2565. I am appealing for 256.
Okay. Yes.
Well, kindly straight back comes to the order of cognizance passed by the learned magistrate.
Yes.
That is order. You lordship kindly come to page
57.
58, madam. 58. This is the order of cognizance passed by the land court below. My lord got it. In a complaint case, learned magistrate has taken cognizance without assigning any region. This is my first submission.
Yes.
In a complaint case. Here, this is a case, my lord, find. Initially, it was registered under section 302 and 120B of IPC.
Yes.
Lord, state government formed a committee and handed over the investigation to crime branch. 10 police officers investigated the matter. And finally, they found this is a case where the husband of the petitioner has expired due to accidental.
Is this case that forest officer
Yes,
something?
yes,
Huh?
yes.
That is
Yes,
it.
yes.
Okay.
A clear case of accidental fire.
Are you ready?
No,
You must tell them. Then it has to be heard. If you are ready, then only I can open. Will not waste time. Then because he change of counsel. Entry mode to continue.
My lord, is short date may be fixed, my lord.
Short date. But he get it ready because this matter is pending since long, 21. There is nothing in this matter.
It was on my
this way, that way.
I'm appearing for the informant. It was on my mention. The matter was listed, my lord.
That's right, but the state council has to be ready. Yes, we can't waste time in item 1 for. The entry mode will continue. Yes.
I have a request, please, that will not cause inconvenience because this matter will take some time. If your lordship specifically taken up the matter at 2 p.m., it would be more convenient.
No, it creates a problem because the 2 p.m. with the other matter getting stuck. Rather, once it reaches, I can put it at 3:30 so that I can continue. Even after 4 o'clock also, I can continue and finish it up.
Yes.
I exhaust the board, complete exhaust, all the lawyers will be free. Then after 3:30, you argue, you finish up your whole work, send your junior, get a pass over. I'll put it at 3:30 so that you finish up your work and we'll continue till, even if it is beyond 4:30, we can finish it. That's a good idea. Yes. Date will be. Wait, we'll find out a proper date and give. Yes. Under pressure, he gives the date and lot of hearing matter comes in a particular day, and sometime there is no hearing matter. Because out of the pressure he gives, obviously, that gives little time so that he can find out. Yes. देखिए कि लगे हुए हियरिंग ही परिबो हां सब गुडा लगे देला प्रॉब्लम है देखिए कि लगे दो जल्दी बाजी के वीडियो नहीं जोड़ा टाइम लागे रखी के परे देखिए सेटिंग कर दो यस यस सर
मैं challenging the entire criminal proceeding one.
Yes.
On the ground that the victim and the petitioner married, there is a love relationship between them, and admittedly the victim was minor at that time.
Yes.
They fled from their respective houses, married, and after that, the victim was rescued and affair was lost by the mother of the victim. And in the meantime, and they are already married.
Show me 164 statement.
Well, that was called for.
Yes.
Last second.
Just see 164. Huh?
ଦେଖନ୍ତୁ କେତେଥର
164. That's very important.
ଆସିଲାଣି ଆଜ୍ଞା 164 ଅଛି ନା।
Just check it up.
ହଁ। କୋଉଠି ଆରଥର ଆଉ ଜଣେ କାଉନ୍ସିଲ ଆପିଲ କରିଥିଲେ କହିଲେ ଏଟା ଫାର୍ଷ୍ଟ ଡେଟ୍
1, 2, 3, 4, 5, 6.
ଭୁଲ ଫାଇଲ
This is 3850. Along with the cause list, you just adjust your files. Then only, otherwise, yes. Yes.
Yes.
Yes. Do you have 164?
Yes.
I'll pass it over. You just now you got the file. Yes. Pass it over. Next. Read it. Pass it. Yes.
Petitioner challenges the rejection of 227 application, my lords. My lords, rejection is at annexure 2, my lords. The backdrop of the case is, my lords, the victim in the present case happens to be the niece of the petitioner.
Yes.
There is a long-standing civil dispute, my lords, with regard to the house in question where both the families reside. Admittedly, there is a case and counter case. And, my lords, as part of the recital of the FIR, my lords, lordships may come to page 15, my lords.
No, you are related to the victim.
Dada, again.
Dada, okay.
Admittedly, there is a civil suit pending with regard to partition of the said house where both the families are residing, my lords, at the moment. And it is alleged.
POXO is involved. What?
Yes. My lords, 8 POXO, my lords. With that contention, lordships, I want to invite my lords to page 15, my lords. The
50.
recital
1
15, 1 5, my lords.
Okay. Yes.
In the FIR, my lords, she alleged.
Entire case was closed as given by the PP.
You are the informant.
I am the informant. No, I am the husband of the deceased.
Okay.
The trial has been
filed for which offences?
302 and others.
Then what is the problem?
No, the problem is no. Trial has been concluded. But because that is why I wanted to draw your lordship's kind attention to order passed by this honorable court on 27/9/23 at page 23.
Page 23.
My lord. Last para 16.
Yes.
This honorable court had directed that further investigation be made within a period of as early as possible, preferably within 3 months. And this order was passed on 27/9/23. No investigation has been, no further investigation has been concluded. Therefore,
now he says that he has filed charge sheet.
No. Trial has been concluded. Because of this order, he is unable to conclude the trial.
Is the instructions? Further investigation?
No, investigation has not taken place. The trial has been concluded. Let him pass the judgment.
Where does it say that further investigation is completed? What is this? What is he trying to say? In the last paragraph, have you read it? What does he say? Read it. In view of who? What is he writing? You read it.
View of the continuous and persistent dragging by the.
Who is dragging? The court is dragging him.
What is this? That's professor. To complete.
Who? He is an investigating officer. How can he use this kind of language against in court? Who is this officer?
Being pressure, that means you are hearing pressure.
He says that in view of continuous and persistent dragging by the honorable court of third so and so, I have submitted the charge sheet. Otherwise, you would not have done it. He should resign then.
Because of the court direction.
Okay, call him to let him appear. This is no way of addressing to a court. He's an he's DCP or something. What is he saying? Because the court has dragged him, therefore he filed charge sheet. Otherwise, he would not have done it. Not he has to learn how to behave. This is no way. Call him. The written instruction. Paragraph then. The written counsel for the state submitted a written instruction issued by the IO of the case. The last paragraph of the instruction reads, this court is taking a serious exception to the language employed in the instruction. Therefore, the IO, Asutosh Mishra, is directed to explain. What is this?
Yes, sir.
These people are thinking as if they are above everything. Let him appear.
Yes.
And you tell him.
Yes.
They should respect the court and
Proper language.
yes.
Tomorrow.
No.
No.
Through let him appear through VC.
Yes.
Through VC. Yeah? Through VC. Give it. And tell him
Yes,
to learn how to write.
And 6.
The last paragraph uttar do. Instruction da de debe apun tiki. Last paragraph uttar. Yes.
May it please your lordship. Your lordship, NBW non-bailable warrant was issued against the petitioner.
NBW.
Yes, sir. Yes, your lordship.
Order 123.
Yes, with the order number 50.
NBW.
It is at page number 8.
1 minute. NBW dated
7/1/23.
7/1/23.
Yes, your lordship.
Okay. You are on bail?
Yes, your lordship.
Give the date of bail.
So bail was.
Was he on bail?
Yes, sir.
On bail लिख दो यार. चलो 500. Yes. Next.
Item 7.
Yes.
May regular case arising out of complaint case by way of a protest petition on being aggrieved on the Miller, non-submission of charge sheet in respect of the Kottagoda PS case number 41 of 2024. Look into the charge sheet file. I am the accused person.
I am on behalf of the complainant. I am instructed to
Okay. So entered appearance for the opposite party and submits that he has not received the copy of the petition and I'm directed to file the Wakalatnama within 2 days. Within a week, please the matter for hearing.
NBW since pending against my name. Till that date, no course.
They have availed anticipatory bail order. They have not surrendered.
Okay, now he will surrender. 15th of March, he will surrender, appear, and resort to the remedy available to him. Lease the matter after 15th. Yes. You go on till then, no course of action. 15th March, no course of action.
In pursuant to the 438 order.
Whatever.
Yes,
No course of action.
Yes.
NBW issued on when date? You tell me.
Yes.
Do you have the date?
Yes, ma'am. I annex the order.
Give me the date. It is admitted that on
NBW order, different dates are there.
6/11/2000.
Okay. সেটা তো মা appeal করবো লাগবে।
Immediate of NBW.
Yes,
I want to say that everything is done in the orally. Within any date, anything, NBW is issue. Where is it? Where have you written? Where is the order?
অডুয়া আছে স্যার কনসেন্ট বিল অ্যাপিয়ার করতে ଅଛି
छोड़ो, simply adjourn कर दो.
না 18/11/2024 সার্টিফাইড কপি ଅଛି
Then tell me, why are you telling that? By the order dated 18/11.
2024
NBW has been issued against
12/11
petitioner, and then for the petitioner
ମୋ ନାଁରେ ଚାର୍ଜସିଟ୍ ନାହିଁ ହଉଛି
submits that he would appear surrender before the court on or before 15th of March. 15th of March, and resort to remedy with him under law. তারপরে সেটা লিখে দেবো whatever you want to do till 15th of March, no course. Yes. And 15th March for a good date level. Yes. Go and appear and do whatever you want. Yes.
Item 8.
তারপরে সেটা লিখে দেবো
Wait, please, Your Lordship. Lord, in this matter, the CBI at last time sought time for obtaining instructions. They have not filed anything, no reply.
File reply, Your Lordships.
Yes, Mr. Naik.
Sir, aji file karibe. Aji
karibe.
Aage.
Mr. Naik and counsel for the opposite party submits that he would be filing counter affidavit during the course of the day within 2 days. Within 2 days, and advance copy we supplied to Mr. Moon, then counsel for the petitioner. This is the matter for hearing. Yes.
Milord, the matter is posted to 21st in the trial court. I may be protected for that date only, 21st.
Yes, Mr. Naik, what do you say?
Yes, Your Lordships, let this matter be listed in March and 21st, whatever service.
21st, let him admits that the matter is listed before the trial court on 21st of February. Therefore, he may move an application for an adjournment on that day. Please the matter for hearing in the March for settlement. Yes.
Wait, please, Your Lord. There is a case, counter case. Uncle and nephew. Informants are uncle and nephew. They have compromised.
Uncle and nephew.
Both of them present.
What are the offense? Oh, 323. Yes. So, yes.
Yes, Your Honor. Case and counter case. Another matter with
The other matter is also there.
Yes, sir. Which item, Your Honor?
Both the matters, huh?
2699.
Here, who is the informant here? First matter?
First matter, informant is
First matter is the informant.
Huh?
Dilip Das.
Prasanna Kumar.
Petitioner number of opposite party number 4.
Prashant Kumar Das.
Prashant Kumar Das.
Informant present, Your Honor.
1 minute.
Both.
I clear. Every clear she is right. Dilip Kumar. Ashok Das is accused. It is.
In one case, Dilip Das is the informant, and in another case, Prashant Das is the informant.
In 217.
A separate order has to be passed. Where is Dilip Das? Fullarani? Where are the petitioners? Where are the petitioners and opposite party? Prashant Kumar Das.
Prashant Das.
Where is the petitioner number 2? Where is the petitioner number 2? Yeah. Where is Ashok Kumar Das?
Ashok Kumar Das is the father of the Prashant.
Where is he? All of them has to be there. Otherwise, how will I do it? How will I pass? And who is Dilip Kumar? Dilip Kumar Das.
Dilip Kumar Das is present.
Dilip Kumar Das and who is present? Prashant.
Prashant Kumar.
And what about the other people? What about the other people? What about the other people?
Lordship,
Online, bring them online, I'll do it.
Lordship pursuant to Lordship direction from last year, the Lordship directed me to call both the informant. So for that purpose,
No, I have not said anything. I have to see, it is a, if you have settled a dispute, the parties has to be there.
Yes.
Tomorrow somebody will come and make an application that I have never given consent.
No.
We have faced this situation here.
Lordship. No, case and counter.
In absence, if some order is passed, tomorrow he will come. Do you have power of attorney for all the people? Have you filed the wakalatnama for them? Not, it doesn't have any. You should have some clue. You don't have power of attorney. You don't have anything. If parties are not there, how can you make statement for them?
Already I will file the power.
You get it. Yes, next. 2 o'clock, whatever you want to do by 2 o'clock. Yes. We'll finish up. Small matter unnecessary.
Yes. I have the power. I have the power in
2 o'clock. Ask them to appear through VC. Yes. If they don't come, then you move an application if you have power of attorney. Seeking exemption or something.
Your Lordship may keep it some other.
Tomorrow?
Tomorrow.
Yes. 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 10.
394, pursuant of the entire proceeding by virtue of an compromise, that is affidavit is annexed filed by way of an additional document, Your Lordship.
So nobody has come. Pass out. Yes.
12. Well, Lordship, the pursuant of.
Yes.
Passing of the NBW.
NBW. Tell me when the NBW was issued. NBW was issued on.
Charge their choppies.
On 3 charges.
Their choppies while the case is posted for accused statement, Your Lordship. 138
138. The petitioner is an accused in ICC case number 605 of 2015 under section 138. When the accused statement was to be recorded, the petitioner remained absent, as a result of which the NBW has been issued by the impugn order dated 29/4/2024. Sorry, yes, 500. Yes. Next.
13 made with Lordships. Petition is paid for passive cognizance, Lordships. Cognizance order is Annex 3, case 39, Lordships.
Yes.
Before going to cognizance order, Lordships, Lordships to come to the FIR, Lordships.
The 307.
307 with other offences. This petition, they are.
Yes.
This petition name is Lakshmi Priya Tripathi.
Yes.
The FIR, Lordships has page 10.
Come to the charge sheet.
Charge sheet, Lordships. I am coming, Your Lordship, sir, to the charge sheet, Lordship.
Yes, what do you want to say?
Your Lordships, in the FIR, there is absolutely no allegation against the petitioner.
FIR is not required. After investigation, what has come against you?
Page 31, Your Lordships. That is the 161 statement of the informant.
Yes.
Later on, it has been added in against me, Your Lordship.
That is why the investigation.
Yes, Lordship. Santanu Kumar Sahu ତାଙ୍କ ସ୍ତ୍ରୀକୁ ଧରିବାକୁ ଚେଷ୍ଟା କଲେ ଏହି ସମୟରେ ଅନ୍ୟ ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ଯାହାର ନାମ ଲକ୍ଷ୍ମୀପ୍ରିୟା ତ୍ରିପାଠୀ ଘର ଭିତରକୁ ବାହାରି ଆସି ସେମାନଙ୍କ ସହିତ ମିଶି ମତେ ଅଭଦ୍ର ଭାଷାରେ ଗାଳିମନ୍ଦ କରିବା ସହିତ ଜୀବନ ମାରିଦେବାର ଧମକ ଦେଲେ. That is the allegation, Lordship. Supreme Court says, Lordships, if there is absolutely no allegation against you in the FIR, Lordships, subsequently you cannot add the.
No.
That is the judgment, Lordships.
Then in the FIR says only everything has to be there. No.
Yeah, Lordships,
that in the FIR, what has happened? Therefore, investigation. FIR is just information of the incident.
That is BL John.
Then according to you, if I'll go by your argument, if anybody's name is not there in the FIR, no charge sheet can be filed.
The charge sheet can be filed.
Then,
but if there is absolutely no accusation. Later on,
the incident had happened, the incident was reported and it was investigated and it was found that you are also involved.
The informant was there. What happened, Lordships? Some police personnel came to gone to arrest one person, Lordships. her wife and accused, they have been arrested. But this is the third person, Lordship.
Yes. I'll stay the NBW which has been issued and go and argue all this.
Your Lordships, I have already bailed your Lordships.
Yeah, bail.
I am already bailed.
There is NBW issued again.
NBW, the latter one I have already bailed your Lordships.
Okay. Where is that judgment? Just to me. On to invite. Yes. Yes. Which part of the judgment?
Page 30, para 34, your Lordships.
34, yes.
That has been. As noted at discourse paper, nothing was mentioned in the complaint paper of any specific act apart from alleging that the appellant and his partner.
These are on the facts of that case. How are you bringing?
Your Lordships.
These are is this the ratio or disandi?
Yes, Lordship. That is.
Why are you saying that? Can it be there? Can there be a ratio of this nature? That once the name is not then the FIR, you can't be
accusation, Lordship. That is the
no incident is alleged and
Lordships can you see Lordships can
yes FIR so me yes yes
page 10 para 5 Lordships can you see
yes
5-6 at this juncture of time the arrested accused Santanu Kumar Sahu and his complaint namely his wife Srimati Rajani and Sahu turned amok and started in taking away the arrested accused Santanu Kumar Sahu from police custody by dragging him from the police custody. I being the lady police officer while tried to restrain the arrested accused Santanu Kumar Sahu from the clutches of lady accused person from his escape from the police custody was utterly justly by the lady accused persons with a full and slang threat.
Lady accused persons. Then
before your Lordship, I being the lady police officer while tried to restrain the accused arrested accused Santanu Kumar Sahu from the clutches of lady accused person from his escape from police custody was utterly justly by the lady accused persons with full and slang threat ridden language towards herself.
Come to all these trio persons, namely Santanu Kumar Sahu, Rajarani. And who else third?
Two other police personnel. That lady also pressed my.
Oh no, then who is the third?
I am Lucky Priya, Lordship.
Then he says 3 persons were there, 2 names were disclosed. The third person is you. That is the charge sheet. Sir, argue that. Very specific case in the FIR also.
What happened in this?
You want me to dispose upon merit or you will? Argue that
your Lordship, I will argue the matter before the framing of charge.
You will argue that?
I will submit.
You move application there?
Yes.
Right. Item 13. A petitioner has challenged the order dated 22/8/2023 passed by the SDJM Dhankanal in GR case number 287 of 2023, whereby cognizance of offences punishable under section 307, 323, 294, 506, 353, 332, 333, 225, and 324 and 34 has been taken against the petitioner and other 2 accused persons. And counsel for the petitioner, by taking me to the contents of FIR, submits that there was no allegation against the petitioner in the FIR. And subsequently, however, in the charge sheet, the petitioner has been implicated as the third accused. He has relied upon the judgment of the Supreme Court in criminal appeal number service criminal number 2184 of 2024, D and John versus State of UP and another, and submits that the Supreme Court has categorically held that once there is no categorically held that in the event in the FIR or public complaint, any specific act or overtake is not attributed to an accused. In the subsequent stage, the version of the improvised and improvised. And he submits that this is exactly the same situation that has happened in the instant case. On the initial stage, there was no complaint against. There is no overtake attributed to the petitioner. However, in the charge sheet, the implicated as an accused. I am not inclined to entertain this petition at this stage when only cognizance has been taken. However, the petitioner is at liberty to urge all these points before the court below by moving specific application at the time of framing of charges.
That lordships only at the best lordships 294 526.
So that therefore in charge state only you can distinguish. So many offences are implicated. See, if you take you start fighting with police officer, this will happen. Entire IPC they will invoke.
In fact,
Entire IPC, they have not left anything.
But while the incident was going on, he was recording in Mumbai. That is his.
So many provisions will go and remove specific application. Yes. Yes.
May we pardon, ma'am?
Yes.
Item number 9.
9 is done.
Will not stand it for mediation.
Mediation. Why don't you bring them? I'll quash it. Where is the question of mediation? You have already settled the dispute. You say.
Yes, settled.
Then there is a doubt.
No. Some people are suffering. They cannot come. That is the problem.
So if that is what I said. If you have wakalatnama, you can move an application seeking exemption of their personal appearance.
Yes, that will be better.
Then also I can think of, because I've seen one of them is 70 years old and all. You have to file an wakalatnama on them and move an application that for this reason they are not able to appear.
Yes.
Then I can.
That is better.
So
yes.
Tomorrow.
Next Monday. Next Monday.
Okay. 3 तारीख 3-4 and file an application beforehand if they can't come, explaining the reasons so that I can exempt them. Yes.
14. Item number 15 I'm going for answer. 15.
My lord, I am in BC, my lord.
Yes.
This CRLMC is filed to quash the charge sheet and cognizance order of GR case number 392 of 23 pending before JMFP Koktupuri. My lord, case and counter case are there. Complainant has recently expressed willingness to compromise with petitioner. The pending related case CRLMC number 1219 of 24 and CRLMC number 2161 of 24.
Give the numbers. All the numbers.
My lord, 1219 of 24 and 216 and 2161 of 24.
List this matter along with this. Yes. Yes.
16.
Application. Praying petitioner who praying with the prayer ballot that the petitioner who is in custody since last 2-3 years to send him to medical board. The sense ballot he was a schizophrenia patient since last 10-15 years. But my application was rejected by the London trial court. Saying that the jail doctor says he is okay, he was schizophrenic and that at present he is okay. So I have no prayer. I'm in custody. I will be in custody. I am also not prayed for stay of the trial.
Just seeking
that particular time space 24 hours. The London trial court has clearly opined that I have UTP and it's clearly
for that reason I said instead of
I'll tell you, schizophrenia people sometimes behave perfectly, sometimes they don't behave properly. And what time the question was put, I don't know. So don't go by that. Get instruction. Schizophrenic means they are every time they are not like that. Sometimes they behave very dangerously. Sometimes they are very cool. So that is the. So what time he has asked, I don't know.
My specific prayer balance.
And those kind of people are dangerous also in the jail. Just check it up. I'm just issuing.
One doctor, 2 doctor ballot, he can be gained over or she can be gained over. But by the board, I say by the board.
You check it up, huh? Yes. Get instruction. Yes. Yes.
70.
That's 17.
Yes. 17. Yes. Yes, sir.
Already in the meantime, at my lord, metro I wanted to settle among them.
You're settling to issue. Yes.
My
I'm
lord,
I'm appearing for the informant.
Appearing for
Informant.
informant. Okay.
your lordship fix a date. There.
Okay. Also entered appearance for the informant and both the counsel appearing for the parties conjointly submits that the parties have settled the dispute. Please the matter on subject. Yes. First week. Yes. Yes.
First March, man.
First week. Yes, yes, Mr. Pota.
Possible item 14.
14?
Okay. Just pass.
Every time you ask me to go in the reverse direction.
And this is my problem.
Okay.
As a
Okay.
separate mention करके ऐसा लगा.
Petition for discharge rejected.
I have.
And nowadays you are very busy. You allow your juniors to argue also. Small matter. Every matter you want to do. Your junior could have done it better. You encourage. Yes. Yes.
I have given.
Also directly file the 161 statement in charge sheet. Now in the meantime, Reliance has already filed charge sheet and 161 statement. And from the bare perusal of the statement on record 161 of the informant has clearly made out that the SC Act, Your Honor. So for my response,
Yes. Let us see this.
Yes, Your Honor.
consequence. Yes.
Malathi Singh. The
Yes.
statement of Malathi Singh.
I
Yes.
can have a class with the FAIR. It's 13 madam.
Yes. 1-3. Yes.
Approximately କାମ କରୁଥିବା ସମୟରେ ପାଚିଲାଟି ହଠାତ୍ ମୋ ସ୍ୱାମୀ ଓ ମିର୍ଜା ଜୁଡୁ ଉପରେ ଧସି ପଡେ ମୋ ସ୍ୱାମୀଙ୍କ ଡାହାଣ ଗୋଡ ଭୁଗା ହାଡ ବାମ ଗୋଡ ହାତ ତଳୁ ନଳି ଗୋଡର ଦୁଇଟି ହାତ ଫୁଟିବା ସହିତ ମିର୍ଜା ଜୁଡୁର ମଧ୍ୟ ଡାହାଣ ଗୋଡ ଜଙ୍ଘ ହାତ ହୋଇଛି ଘଟଣା ପରେ ମଲ୍ଲିକ ସତ୍ୟ ହୋଇଛି ପ୍ରେଜେଣ୍ଟେସନ କରି ଖବର ପାଇ ଲୋକ ପଠାଇ ଅଟୋଲୋକେ 2 ଜଣଙ୍କୁ ନେଇକି ପଣ୍ଡିତ ରଘୁନାଥ ମେଡିକାଲରେ ଭର୍ତ୍ତି କରି ଚିକିତ୍ସା କଲେ ସନ୍ଧ୍ୟା 5 ଟା ସରକାରୀ ଡାକ୍ତରଖାନାରେ ଚିକିତ୍ସା ହେଉଛି ଡାକ୍ତର ମୋ ସ୍ୱାମୀ ଓ ମିର୍ଜା ଜୁଡୁ 2 ଜଣଙ୍କୁ କଟକ ନେବାକୁ ରହିଲେ ଆମର ପଇସା ପତ୍ର ନଥିବାରୁ ଆମେ କଟକରେ ପରିବାର ଠିକ କରିବା ମାଲିକ ସତ୍ୟ କହିଲେ ମୁଁ କୋଉଠି କହିବି ସେଇ ନର୍ସିଂହୋମରେ ଚିକିତ୍ସା କଲେ ଖର୍ଚ୍ଚ ହେଇଛି ଏହା କହି ଜୀବନ ଦୀପକୁ 2 ଜଣଙ୍କୁ ନେଇ ଭର୍ତ୍ତି କଲେ ଓ ଆମକୁ ନିଜ କୃଷକ କଲ୍ୟାଣ ଯୋଜନା କାର୍ଡ ଆଧାର ଗଲେ ମାତ୍ର ଆମ ସତ୍ୟ ନଥିବାରୁ ସେଠାରେ ଆମର ଅପରେସନ ହୋଇପାରୁନି ଏବଂ ମାଲିକ ବକେୟା ମଜୁରୀ ଯଦି ପୁରୁଣା ଆଦାୟ କଥା ଜୀବନରେ ସୁରକ୍ଷା ପ୍ରଦାନ କଲା so the FAIR to give money on the final guideline class to charge sheet.
Yes. Yes.
କାମ କରୁଥିବା ସମୟରେ ତାଙ୍କ ଗୋଡଟା ଫ୍ରାକ୍ଚର ହେଲା ମାଲିକ ହିସାବରେ ବନେଇ ରିପେୟାର ପଇସା ଏବିଅର
Let me complete. Let me complete.
Yes, yes.
Let me complete.
Yes, yes. Go ahead. Go ahead.
No, who is to act first?
Okay, go ahead. Go ahead. Yes.
Page 21 madam.
As the investigation case has been completed and privacy evidence is well established under section 337, 338 to 95 relative section. The accused against Shakti Kumar, son of so and so, Burger, hence I submitted charge sheet by Balikoda, Southern PS case number so and so against the above person in the court of law which can be assembled. So the 161, there is no whisper that there was no cement factory and it was demolished since 30 years. Out and out, it is a false case. And the 161 statement, which was prepared by the IO only after thought, neither in the affair, and 161 statement was recorded on 7/1/21. And in the affair itself, it has not been written. And the CS is not recorded because it was not in a public place. And no factory was there since 30 years.
What is the material you have that factory was not there?
That document,
That's the problem. Last time also I told you to file document.
When I have filed 161 and the other document.
And the 161, there is a specific allegation against you.
Regarding cement factory, I produced.
So for every hearing, if some question is put, you will ask for adjournment to bring the document.
I am written in my petition, since 30 years it has been happening.
No, these things have to be settled in the trial only. How can I go into all these things? Factory was there, factory was not there. I have to only see 161 statement where she is making very specific allegation.
But it was not in a public place.
All these things you have to put to the witness when the cross examination. I don't think you have a case unnecessary. It shouldn't be. So you are challenging what? You are challenging.
Huh? Yeah, earlier careless was filed. Pursuant to order passed by this allowed, I filed discharge petition, and discharge petition was rejected by the court. Challenging them.
I don't think you have a case. I'll pass the order. Okay, I'll pass the order. This is an pass the order.
18.
Item 18, kindly be passed.
Kindly be
passed over, Lordship.
pass over.
Lordship,
here they have challenged the cognizance order. In my file, there is no such cognizance order available.
18,
18. And they have stated that the charge sheet has been filed, no charge sheet has been annexed in.
No, cognizance order has been, it is filed here.
As
At
annexed
page
to-
15, 14, 15.
Yes. My page, it is available, at page 13. There are-
Why don't you give full copy?
Lordship,
Let the counsel for
I
the
already been
state
filed.
submits that he has not received the copy of the petition. Let the counsel for the petitioner supply. the
Also, your
entire
lordship may direct
set
that to
of
file the
copy.
charge.
Petitioner is also directed to
Thank
file the copy of the charge sheet. Please the matter.
Okay.
Yes.
19.
File the charge sheet. Yes.
19, Lordship, it is the PMLA matter wherein it was submitted that cognizance taken against the public servant for the offense of the PMLA is not maintainable in view of the fact that no sanction for prosecution is obtained under section 197 of the CRPC. On the last date, I submitted the judgment of the Honorable Apex Directorate of Enforcement versus Bibu Prasad Acharya, etc. Lordship may kindly come to para 15 of the judgment.
Give me the judgment. Do you have the judgment?
Para 15 of the judgment, Lordship may kindly see.
Yeah. Para 15.
Lordship.
Yes.
We have carefully, Lordship got it. Para
I'm there.
15.
I'm there. Read it.
We have carefully perused the allegations against the respondents in the complaint. The allegation against the second respondent is of an additional 10 lakh liters of water to India Cement Limited, taking the averments made in the complaint against him as it is. The act alleged against him has been committed by him while purporting to act in the discharge of his official duties. The allegation against the first respondent is of the allotment of land measuring 250 acres to Mrs. Indutech Zone Private Limited, taking the averments made in the complaint as correct. The act alleged against him has been done by him.
Applies to PMLA also.
Lordship also apply to PMLA.
I read it.
And they were public servants, and it is alleged that they committed criminal misconduct by causing illegal gain to themselves.
Yes.
That is the allegation, Lordship.
Yes.
And the allegation against me is for the offense under section 13(1)(b) of the Prevention of Corruption Act. Lordship may kindly see section 13(1)(b) of the Prevention of Corruption Act.
Yes. Now, your case is section 65 PMLA says that the CRPC applies. So therefore, 197(1) applies.
Yes,
Sorry.
yes, 197(1) applies.
Yes,
Lordship, one minute. Lordship, the section alleged against me is 13(1)(b). 13(1)(b) reads that a public servant is said to commit the offense of criminal misconduct if he illegally enriches himself during the period of his office.
Now the question is, if in the schedule offense, if sanction is taken,
No.
even in the PMLA it is required or not?
In
That's
the
question.
PMLA, it is needed. In this,
Separate sanction.
separate sanction.
Under
is needed.
197(1).
197(1).
Yes.
Just one more point, Lordship. In the impugned order, the learned trial court has held, page 37, your lordship may kindly see, running page 37.
Yes.
In the present case, the materials brought on the record would prima facie show that the petitioners have earned money which are disproportionate to their known sources of income and then projected the same as untenanted property and continue to enjoy the said properties. It is no part of the duty of a public servant while discharging his official duty to acquire properties disproportionate to known sources of income, which is punishable under the provision of the Prevention of Corruption Act 1980. This finding I am challenging, lordship. This finding is not correct of the learned law.
Finding is pertaining to the schedule offense.
Scheduled offense.
Yes.
And the scheduled offense is committed.
This finding is an incidental finding. It has nothing to do with your PMLA. PMLA is closed because of the schedule offense.
Lordship.
And now come to the sanction part. What do you say?
Offense of belonging law cannot be termed as a offense committed in due discharge of his public duty. So lordship kindly see paragraph 5 of that judgment.
Paragraph
5.
5 of?
That very same judgment.
Judgment 5. Okay.
Yes.
Section 197 is at page 4, my lord.
Yes.
Section 197 has been quoted, my lord.
Yes.
When any person who is or was a judge or magistrate or a public servant not removable from his office save by or with the sanction is accused of any offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duty, no court shall take cognizance of such offense.
Yes.
There is no dispute, my lord, about that. And your lordship may paragraph 6 at page 6.
Yes.
The object of section 197(1) must be considered here. The object is to protect the public servants from prosecutions. It ensures that the public servants are not prosecuted for anything they do in discharge of their duties. This provision is for the protection of honest and sincere officers. However, the protection not unqualified, they can be prosecuted with the previous sanction from the appropriate government.
Yes.
The expression to have been committed by him while acting or purporting to act in discharge of his official duty has been judicially interpreted. A bench of 3 honorable judges of this
What do you want to say?
My lord, he has committed offense under Money Laundering Act.
Yes.
He had, and that offense he has not committed while discharging his official duty. If your lordship,
But what was the question in this judgment?
The question is, my lord, sanction, that paragraph 15 place, my lord, sanction is required where offense is in discharge of his official duty. What was the allegation, my lord? He had allotted 10 lakh additional liters of water to India Cement in connivance with the chief minister. So the court said that allotment he has done is in official duty. So sanction is required. But here, my lord, they have not filed the complaint. My lord may kindly see the complaint.
No, have you taken sanction under section 19?
Schedule offense sanction has been taken, my lord.
No, it is wrong. This submission is wrong. This submission, no charge sheet has yet been submitted. Yes, that you say. But sanction has been taken.
Sanction is taken or not?
Don't say falsehood in the court.
What?
You are stating falsehood in the court, stating that sanction has been taken for the scheduled offense. It has not been taken.
Your lordship may call it, I will bring it because the scheduled offense record is not.
Yes.
You file a response to that.
Yes, my lord, I will file.
Yes. The case is, lordship, the case is posted to 20th for framing charge. And on that day, I will be allowed to file an application. He is appearing in the trial also.
Why charge is to be stated?
No, there is no question. Cognizance is in law. Cognizance is bad in law.
Can you see the trial court order?
Where is that? Oh, I have read that for 37.
Paragraph 36. The court has taken note of this judgment, not that court has blanketly passed this order.
That is I am challenging. That is what I am challenging. That the court has not appreciated my argument.
In the same case,
That is what I am
The
challenging.
court held that the protection under section 197 CRPC has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty, and merely a clock for doing the objectionable act, section 197 CRPC does not get immediately attracted.
That's your case.
Lordship,
And your lordship, kindly see the complaint. They have not filed the why they have not filed the complaint. He has kindly see how much money cash was deposited.
whatever it may be, but
Money you have not collected in discharge of your duty.
and in that case,
Please don't shout on me. Submit to the court. Don't shout on me.
in that
Don't
case,
shout on
Place
me.
everything on record. I'll see.
in the connected case,
20th.
21st.
21st. Okay.
don't say like that.
Don't shout on me. I said.
Don't say like that.
Cool down. Yes. Next.
20.
20. Yes. Yes.
My lord, the petitioner pray for passing of the cognizance under Annex 2 as well as the criminal prosecution against the present petitioner, my lord. My lord, the alleged offences are 420, 465, 467, 468, 471, for
Yes.
18-120B 201 IPC read with 66 of IT Act. My lord, the entire allegation. My lord, the entire allegation against one accused Hon'Ble Bag. And there is no allegation in the FIR as well as the 161 statement against the.
Where is the charge sheet? Show me the charge.
Can you see the charge sheet under Annex 1 series and 161
Who are you? You
from
are
page 60.
Page 34.
Pulin Kumar.
My lord, Pulin Kumar Gontayata has not played any role in the crime.
Okay.
Your lordship, kindly page 35.
35.
On the production, your lordship, kindly see
Yes.
that in the last portion,
Yes. Yes.
that the questioned documents along with the specimen paragraph admitted document have been sent to the handwriting bureau for examination, comparison and opinion by one date. It was proved that a fake email ID in the name of Sunil Kumar Patnaik, this is informant.
Money is also
was
transferred to your
created.
account.
And
My lord, fake ID, fake.
But your money is also transferred to your account.
My lord,
Yes.
the Hon'Ble bag transport 12 lakh something.
Oh, that is why is where your complexity.
Kindly appreciate the fact, my lord. And in turn, the present petitioner was returned to him. And the balance amount.
Why the money has come to you and all this thing has.
I don't know, because I was previously doing that job, dealing with that management of online exam. Subsequently, the Hon'Ble bag taken over that charge, and he has created false ID for document. My lord, kindly see the entire allegation, and the amount was already returned to him, and the balance of 42,000. Kindly see the certificate issued by the informant under Annex 3.
When the fake things have happened,
my lord,
time period.
that the
Time period,
accused
madam.
person is no,
1 minute. Time period.
none else
Tell
than-
me when the fake document and everything has happened.
my lord, kindly see the FIR.
No, you tell me the dates.
एक के साथ 2020 also working.
2020
My lord,
and the money transferred from
money
9/8/2018 to 29/5/2022.
My lord,
Between that time only everything has happened.
my lord, money.
That time the money has come to you.
My lord, kindly see the statement of the even the informant.
How will you get over this?
My lord,
Manipulation takes place at a particular time.
my lord, that
And
manipulation.
money transfers to your account.
My lord,
And
that-
you don't know why it is transferred. 2018 to 22, money comes to your account. And you don't know why the money
my
comes.
lord, immediately. My lord,
It is an isolated incident, I can understand. Money came in return.
My lord,
And
kindly
the money is flowing to your account.
My lord, if any allegation made against the present petitioner, the offences are not made out against the present petitioner. He has not played any role. My lord, kindly.
Petitioner is agreed by the order dated
Even the certificate issued by the informant.
2022 pass by learned JMFC R Katak in GR case number 1609 of 2022, whereby cognizance of offences punishable under section 420, 418, 465, 467, 468, 471, for IPC, 66 bracket C of IT Act has been taken against the petitioner and the petitioner. How many accused are there?
3 accused.
So 3 accused against 3 accused, including the petitioner. And the investigation in the present case is still kept open under section 173 bracket 8 of
Investigation already closed.
CRPC. And the counsel for the petitioner taking me to the FIR submits that there is no allegation, a IDOP allegation made against the petitioner in the first information report. However, after the investigation is completed, the charge sheet has been filed in case on 10/9/2022, arraying the petitioner as an accused. I have produced the development made in the charge sheet and the statement of the witnesses under section 161 CRPC. And it appears that the petitioner's complicity is it appears that during the period 9/8/2018 to 29/5/2 there are huge money transactions taking place between the principal accused and the petitioner, and subsequently the forging of the documents was also came to light, and the email ID of the petitioner is also employed for the purpose of commission of alleged crime. Therefore, I am not inclined to entertain this petition at this stage. However, petitioner is at liberty to move separate application before the trial court, taking discharge and urging all the point therein. If such application is moved, the same shall be considered on its merits. Yes.
Let's see if I may be pardoned. I missed the date in item number 19. The date Lordship has fixed it to 21st. The case is before the trial court on 20th.
21st only I am keeping it.
21st.
Yes.
The case is before the trial court on
21st,
20th.
I'll take in the morning, don't worry. 21st, yes.
My lord, all the grounds I will take in discharge. Available.
20?
My lord, the petitioner is the husband. Opposite party number the wife. During the some dissension arose. She left the.
Yes, what do you want? 498 and all. You want
498
settle?
to quash the.
Already settled.
Both her husband and wife are present.
Give me. They are separated or what? Staying together? Are they staying together?
13B petition is pending.
Pending?
Yes.
Pending, it is to be, in the next date, it will be finalized.
Both
And the wife has already married to another person
Okay. Before divorce?
Yes.
before divorce.
And she
They
has
have
also.
applied for divorce in page 45.
Gayatri Singh, said that he is informed.
Anyway, sir, Sarkar.
23, what do you want?
Notice has to go.
After secondary.
Agarwal is.
Notice.
Secondary.
Mr. Agarwal is there to accept notice.
And in the
23, I am issuing simple notice.
in the virtual
He can appear and he can file application under 370.
Oh, you why did you move application? 317 you move.
205 has been rejected. He can move
317. But see, if that is the case, then the new judgment I will allow it.
Already, my lord, he has appeared on bond. He has gone.
appeared gone on bonds.
Gone on bond. There, yes,
What do you want? 317 or virtual? I'll dispose it up.
only 205 has been rejected. Whenever 317 is appear.
As and when required, you may
It will
go.
appear.
Otherwise, 317
We have-
and virtual. Right now. Petitioner is agreed by the order dated. You are agreed by which order? Order dated 27/12/2024, passed by the additional special judge PMLA, come special judge CBI 1, Bhubaneswar, whereby his application under section 205 CRPC has been rejected. Rejected. Pass some any orders?
No.
Rejected. Land council for the where is that judgment, Mr. Agarwal?
Sarsamlal, I'll give that.
Sarsamlal judgment.
No, already that part is over. He has already appeared.
Relying upon the taking advantage of the judgment of the Honorable Supreme Court in Sarsamlal and so on. The petitioner has already appeared before the court and submitted the bond. Petitioner submitted bond. The only grievance raised by the petitioner in this petition is they may be allowed to appear before the court through visual mode or through counsel by moving appropriate application. If the petitioner would move application under 317 CRPC for appearing before the court through counsel or through VC, they may be favorably considered. However, as and when the personal appearance of the petitioner is required, the petitioner shall appear before the court. With this observation, the petitioner is disposed of. Both the things are over now. I'll just
MBW is on 24/12/2018, my lord. 18.
Oh, 1000. Yes.
25.
President Mission, my lord, 3 years array, PC Act 13(1), PC Act and 9 of IPC.
Okay.
Bail and first year.
This appeal admitted, realization of fine date.
Bail and bailers.
Mr. Give a copy, yeah?
Yes, I have already saw.
Mr. Das appeal, sir.
28.
Belgium matter, my lord. Student authority there 23, my lord.
Bail?
I have no proper instruction, but the order replaced the phase 14, my lord.
On bail for the public auto rate of the TC 500 to 1000 crore. No, 500 each crore. Yes.
59.
What do you think for
28/1/25.
Yes. Yes, Mr.
28/1/25, my lord, and widow.
Yes. Bail?
My lord, bail of not been mentioned there. Date of bail.
Bail, when you don't read.
So case, my lord.
You have not read it. Para 5. 29/3/2022. Bail. NBW 28/1/2025. 500. Yes.
Paragraph 4, man.
Yes.
30. 29.
29 what?
Okay.
Yes. 30.
6/11/21 bail, man.
Yes. NBW 16/4/2022. 500. Yes.
31.
31 it's a NBW on the care of IO, not on bail, Miller.
He was absconded, charge was filed, and on the prayer of the IO, NBW has been issued by the order dated 2/12/2023. 1000. 500 each. 500 each.
May I please lordship? 32, my lord, Belgium, my lord. 7/7/23 bail, 7/1/25.
7/1/25. NBW, okay. 500. Yes. 500 each.
Issued on 26/6/2024.
10 accused person. 10 accused person.
Yes.
Bail?
They were on bail by the order dated 22/12/2023 and
bail on 23.
23/12/2023 and 24/1/2024.
NBW issued on
26/6/24. Yes.
500 each. High Court bond. Yes.
34.
NBW issued on 24/4/2024 also. Earlier he was on 41 also for
41
7/3/2021 also.
Police bail. 500, yes.
5.
If I, my lord, he was on bail on 10/4/2012. NBW issued on 25/2014.
14,
Yes.
My lord.
okay, 1500. Local bar, huh? Where is that? Jharkhand? Where is it?
My lord,
FIR?
Raulkela.
Raulkela.
Sundargarh.
Sundargarh.
Bar Association, Sundargarh, yes.
36 bail on 24/4/21 and LBW on 26/4/24.
20, 500 each. Raigad.
37 bail on 11/8/2008 manner and LBW on 6/1/22.
22.
Yes.
Okay. 6122. Huh? Okay. 500. Yes.
38
Yes, madam.
My lordship, bail was granted on 28/6/2013 and NBW was issued on 26/12/2024.
24. 500.
39
220.
9 days.
Yes.
The appellant is the government servant during the office hour, the incident taken place, challenging the MSc order. The appeal was filed, thereafter the due to deficit of. I am for the opposite party number 1 to 3, madam.
1 to
3, madam.
3.
The claimants, madam. Accident of the year 2006, madam. The opposite party number 1, the claimant wife of the deceased is deathbed, madam, urgent need of money. And since 17, my lord, the CMAPL is pending, my lord. And this is 25, madam.
What do you?
I am not objecting, it's only my allow so that the MSA will be disposed of and the claimants will get their money, madam. For them negligence, for their negligence,
Okay.
the claimants
For
are suffering, madam.
the reasons stated in the application 332 of 2024, seeking condonation of delay of how many days?
29 days, madam.
To 29 days. The same is allowed. And main CMP is and also allowed. And MACA, na?
Yes, madam.
MACA number 398 of 2015 is restored to its original file. Least the MACA before the roster bench after 2 weeks.
40
Delay of 30 days. 30 days delay, my lordship.
30 days delay, kanon karo. Delay kanon karke restore karo. What restoration you are? Criminal MC. Criminal MC number 435 of 2019 is restored to its original file. Lease the matter, lease the CRLMC after 3 weeks before the roster bench. Yes.
41
41, my lord. I pray 2 weeks time, lordship may grant to file the deposit receipt, my lord. I pray 2 weeks time to file the original deposit receipt, my lord. Well, in this case, I am appearing on behalf of the claimants, my lord. It's a case of death, my lord. Statute mandates are the. I am not raising any serious. I am ready for a compromise. I am not.
Let them deposit the first.
No, matter can be disposed of. Your lordship may there. I am not any objection regarding my friend, my lord. The attitude of the insurance company, my lord. The statute mandates.
So anyway, I am not adjudicating attitude. I am only adjudicating FAO. You get the money.
At this process, in this process, my lord, the claimant is 1 year interest.
Therefore, I am giving 1 week time. Only 1 week time.
On 5th of this February, on 5th of February, they have taken time to deposit the amount.
No, by last opportunity, 1 week time is granted to the petitioner to furnish the deposit slip for which the matter on 4th or 5th. Yes.
5th March,
5th March. Yes.
Oh, bless you.
52
Delay of
31 days.
Can be disposed of.
Delay, 31 days delay, for the reason stated in the application and Para?
Para 4.
ठीक थैंक
Matter for mode of payment, 50% withdrawal, my lord. I made the necessary corrections. Legal office order is there.
you. Delay? How much?
My lord, I'm just.
How much delay?
Yes, my lord, I'm just.
The IA number 1048.
I am appealing for Indian Benjamin.
It's 62 days.
I am appealing for Indian Benjamin.
For the hearing application, delay application. 2 days for filing the allowed. And the
Direct to file the document.
or is he have to convert?
My lord, respond number 1 and 2 are, sorry, appellant number 1 and 2 are major, my lord, and other 2 are minor. The release will be for 50% with regard to appellant number 1 and 2.
1 and?
1 and 2. I have made the
Since
written, my lord.
changes you made.
Yes,
Okay. Yes.
44, my lord, also.
44 ले लो. 44 is 78 also. This is 44. This is 44. This is 44.
I am for them. I made necessary correction. The sole appellant is there, my lord.
78 is 44 ले लो. 70. 70. ठीक है.
44 minus Siddharth Mohan Patnaik.
Please give in writing so that we can enter here. Huh? Please give in writing. Take the appearance, sir. Yes.
My lord, restoration, my lord. My lord.
How much delay? How much delay?
My lord, 115 days delay.
Huh?
115 days delay. My lord,
What are you seeking?
the order passed on 11th 9th 2024.
Revision petition.
My lord, revision.
What revision is this? Charge.
My lord.
What kind of revision this? What is this revision petition?
Against appeal, my lord.
Against?
Appeal.
Okay.
Well,
For the reasons stated in the IA number 3 of 2025, delay of
115 days.
115 days is condoned. The so is allowed. Restored the criminal revision number 320 of 2001 to its original file. Please the criminal revision before the roster bench after 3 weeks.
My lord, I am inside the custody since 31/1/2025. Inside the custody since 31st January. The petition has been filed.
I can't do that. You have asked for restoration, I have allowed it. You have to file there in the revision, you have filed. Yes.
46. So that's that mediation report is at flag and which is successful.
Successful.
Yes, your lordship said fixed it to today because the diary number was not done and today it is done. My saliency application is already that is also registered. So that is number. That's 69.
The other one. Where is that?
With my along with this matter.
690.
690.
Of 2020. On 29 May 2024, the following para 4 and 5. Whether the High Court of Orissa, the partnership, mediation process, and mediation. High leadership in the case that successful. The terms of where is that terms of mediation depends again. Mediation because I have a connection face from I in my black information. And then before has been And finally, and we will report that he wants to one. Anybody can become constituent within the parties. And the patient of the party, how would they and the increase of the party submit the that's not whereby what had happened what was the sort of if I was to say 887 election, what have you asked? Right, what do you do? With order in order that annexure 7 series page 69 whereby the department a clear bond of the and also find about the which is one through like inference the 690 of 2025 this is only since we have depending on the potential citizenship, I feel the plan has done a contribution in the team by the party. Ability to develop parties will be both parties will be and and we need both parties are bound by and parties amount with these objections. So, the remote proceeding which were initially 107 arises out of the FIR. My we have also challenged that FIR is an exception. So, I have FIR reading number 1250. That business in comparison to earlier upward yes. What are you down on?
But other ground is that.
Item 49, I may be permitted through VC, my lords. My lords, there is a noting that due to non-filing of requisites, notice could not be issued. So 2 days time may be granted for the said purpose, my lords. Another prayer, my lords. Instead of OP number 2, notice is to be issued to OP number 1, my lords. OP number 2 is a juristic person, not a real person, who is managed by OP number 1.
Fix it to 24 or 25 more party like that. And the second way they are signed there, that is another. Nay, I'll put it on. Third of. From the people also not developed. Next week. Tomorrow, because the enforcement order issued, the opposite party, the wife is suffering from fever. So may not be, they have to. 20th, or 20th. Because the 490 then if the party they have settled, it's better that you dispose it up. Otherwise, not any people link up then no, do it on you have to tomorrow. Yeah. If they don't come, do VGA.
Let 52 take for Passover.
After lunch.
After lunch, lunch.
What is this matter? That police officer accused by another police officer of smoking. Passover. Absolutely. The professor of retired professor of Orissa College in Mediation. And he was superintendent of East Hospital. Personally, this man was a Mexican walk and the allegations are ugly. This lady actually stayed for only 15 days with her in the house. Yes, pushed up to her husband. We appearing for opposite party. Yeah, that's right.
The contract will file the 2 year also 6 year also pending.
We also gave an offer. We also gave an offer to settle. Now, we offered her 20 to 25 years. After my capacity manager, I am I joined the account. I said, whatever it is, God is good job. We want to get rid of this. Now,
Your son has married.
Son, what is he doing? Son is working in a private job. For 17, 16 years.
Then Salah is sending to mediation. There is let come. We pursue it. What is it? I see. You may keep on fighting with your husband. You understand the old man. So let's see what is happening. You want to learn with your husband. You do die whatever you want. Why the old parents and legally? And this is only pressurizing. To penalize your husband, you inflict injury on the parent.
Incident happened 5 years ago. That is exact precisely the classic case for the.
Are you appealing? No. Who is taking it?
Somebody, why yesterday
Shall I pass it over? Tomorrow, tomorrow. Let them keep on fighting. We can stop them. The old man has to be out. That's all. Yes. Yes. Schools for the business. What is going to be? And then I'll day after tomorrow when I'll be possible. There's a lot of pressure to come. Everything will be there.
I'm surprised for that increment. I'm the wife now.
Then I'll have to pass over.
It has been stopped now. Maintenance case, DB case.
I know, then I'll have to hear it then. Pass over or
Sorted may be.
sorted the next week the put up. Okay. None appears for the petitioner. And so and so appears for the opposite party. In the interest of justice and entry vote to party.
Okay.
6 Millers, may humbly submit, I may be given liberty to all these points at the frame of charge. My consent may not be noted, Millers. My consent to dispose it of may not be noted, Millers, but.
Okay.
I'm appearing for.
The order dated 27/11/2019 passed by SDJM Puri in GR case number 1415 of 2017 arising out of Balipatna PS case number 62 of 2017 whereby the court below has taken of offences punishable under section 419, 420 IPC. So, what are the grounds here?
Grounds here and that, Millers, this is purely a civil transaction.
The counsel for the petitioner taking me to the allegation in the FIR as well as in charge sheet, try to impress upon the court that this is a pure and simple civil dispute, and the opposite party has given a criminal color to the arm to the petitioner. And
I'm
he has.
appearing for the opposite part number 2, my lords. Let's herein my signatures have been forced.
Will you settle? I'll send it to mediation. What do you say?
No, sir, I have to seek instructions to that effect. The petitioner is a 65-year-old lady, Millers.
So why don't you settle?
This
Settle. She old man or she this lady?
The complainant is also very old now. He's probably 70.
So if you want to fight it out, Otherwise, settle it.
Let's let it go.
Only 420. There is nothing.
Let it go to mediation.
Look at your age.
Let's let it go to the trial.
Mediation, I am sending it to mediation. What do you want?
Let it go to the trials, my lord. Let the trial happen because the signatures have been forced.
Both of you want to die in the jail. What will you get out of it? What is it? Look at your age. Look at his age.
Let's will take my lord's
Fighting.
commission. Will try mediation before.
I'm telling you mediation, try it. If it doesn't happen, then we'll see what can be done.
No.
The allegations are very minor allegations. Yeah. So and so entered appearance for opposite party. I'm not inclined to I'm not inclined to entertain this position at this stage. So and so entered into appearance. Having regard to the nature of the allegation and age of the petitioner and opposite party number two. I feel it appropriate to refer the matter to mediation center. High Court Mediation Center for exploring the possibility of settlement. Both the counsel appearing for the parties are also of the similar view. Hence, matter is relegated to the High Court Mediation Center.
Let's Puri Millets.
Huh?
Puri Millets.
Puri High Court. Puri District Mediation Center.
Let it be in the High Court Mediation Center, because this man is hard of hearing, my lords. It's very difficult.
Where is he?
Both of them are in Puri
No,
Millets.
my lords. He is staying in Cuttack, my lords.
No,
Upper
you,
side, upper side.
you have to come because you are the queue. You have to come High Court. High Court Mediation. Awaiting mediation report. Yes. Yes. Yep.
Sir.
Grateful. I am for the petition of
Mediation. No, I feel it to any other day for final disposal. We short note prepared, but recast to something.
Well, mediation matter was referred to mediation center, High Court Mediation Center. The parties have although participated in the mediation process, but the mediation has become unsuccessful. Accordingly, a report dated 19/7/2024 is placed before the court. At least the matter for final disposal. Yes.
Date we have.
April message. April message. Yes, in the meantime, I will be ready.
Yes.
After.
He can later he has a family function. Yes.
Okay.
50?
58.
Wait, made preserve.
That is entry order.
Entry more to continue.
Made preserve. Here, the petitioner has challenged the order passed by the trial court, allowing the application filed under section 19 of the Criminal Procedure Code. Well, let me kindly see the order dated 2/5/2023 at page 26.
Who is appearing? Mr.
My lord, I am appearing for the informant.
Huh?
I am appearing for the informant.
For
My lord.
informant.
My lord.
You are appearing for state. Are you ready?
Before my learned seniors starts the argue, my main point is whether the 482 application is maintainable, allowing the 319 CRPC petition. That is the question, madam. I have relied on a decision. That particular issue has been decided.
Yes.
Lordship, the para 8, the issue has been settled. Page 796, para 8. Before, no, this is Supreme.
Judge.
Before going into the merit of the case, we would, your Lordship.
Just check it up, sir.
Yes,
Madam, you just give the copy.
Yes.
Lease the matter for entry mode to continue. You also just check it up. If 482 is not maintained, then end of the issue.
Yes.
You file. Better withdraw and whatever you want.
Sibo case paying we have
Yes.
to
Lease the matter for him. Yes.
Compromise matter, my lord. Both petitioner and victim got married, or the notice was issued. The opposite party number.
It has been adjourned to which?
Then he given it. Second week.
The entry matter.
Entry mode.
Well, the notice was issued to the opposite party number 2, informer, but he has not appeared till today.
Let us see.
Again and again, notice given.
We have notice through IS. I have intimated the ISC is to give the information.
Acha, acha. Persons to order dated 3/1/2025. The IIC has as to whether the IIC has served the opposite party number 2 or not. No instruction has been received by the State Council, hence he takes an agreement. Yes.
Interim to continue.
Interim to continue. Yes.
61.
My instructions are in the meantime, my lord, this case has turned to 304A, my lords. But my lords, if your lordship will direct for updated CD, my lords, in the last occasion, your lordship also directed for updated CD.
30.
My lords, here the case is that, my lords.
It was a 302.
302, and it has turned to 304A, my lords.
Is it so?
With CD. We have not opted this.
Then you are seeking quashing of.
My lords, here the case is that
now if you know that 304, then file a fresh one.
Charge sheet is not yet filed, my lords. My instruction there, ma'am, if you opted up.
Update sheet, yeah. Yes.
Short date. Great.
62.
In this case, madam, I am appealing for the opposite party. Madam, on same valuation, another CLMC is filed, madam. Let both the case may be had together, madam.
Is it so?
Sale is a file person. Kon 2797 CLMC.
2797. Tag कर दे 2797 कर लगे हैं.
24.
Tag कर दे. Okay. Soon to enter appearance for opposite 2 and submit that similar petition being CRLMC so is also pending.
Other accused person order say.
For the other accused person, please the matter.
Other accused person.
Entry mode to continue. Yes.
64.
Yes, sir.
63, my lord.
I was seeking time because I did not find him. That is why I have to remain present.
I see. I can't object because due to my elder brothers taking time. Interim order is there.
Interim order is continue. And you tell me.
Why, my lord? It will
you tell me a date, common date.
Next week or Friday.
Yes, no.
Friday. Your lordship judgment is there. I have annexed. There is a dispute between advocate and doctor. I am for the doctor, professor of medicine and his wife.
What dispute?
That is the civil dispute. I have appearing on behalf of the opposite party in that case. Your lordship quashed the case. And what submission has been made?
He is appearing for the lawyer.
On relevant day, my sister, Madam Mahapatram.
See, he will speak because he is appearing for a paid client. So he will have to speak. And you are appearing for a non-paid client. You have to keep quiet. And he has to justify.
Because, my lord, my plight before the lordship, he is one of the sister of the practicing lawyer of this honorable court. This is the difficulty. Both are same footing.
Next week.
20 feet. 20 feet. Entry order is there.
Entry order to continue.
May I please?
Yes.
Challenging the criminal proceeding, my lord, and the alleged offences under section 143, 146, 149, 283 of this, my lord. And maximum punishment is 6 months, my lord.
Yes.
At the time of occurrence, the petitioner was juvenile and no allegation against him, my lord. He was just present, my lord. The allegation is that, my lord.
Already undergone.
No, my lord.
6 months.
No, 6 months.
You said 6 months?
Charge sheet filed, my lord.
Okay.
Maximum punishment is 6 months conviction.
What do you want now?
Challenge the quashing of criminal proceeding, my lord. At the time of occurrence, petitioner was a juvenile, my lord. Now he is a student, my lord. He is qualified for the NET exam, my lord. And continuance of proceeding will affect his career, my lord. And no allegation, no specific role played by the petitioner, my lord.
But in charge sheet, his name has been
Yes, that I don't dispute that.
reflected on the.
What are the allegations?
Allegation is that, my lord, under the leadership of one political party, my lord, they made a action against the local policeman.
Sena, Odisha Suraksha Sena.
A young boy, why are you after his life? Leave him, let him, he started his career and you are after him. What are these allegations? You might have.
I've annexed the FIR, my lord, but in the FIR, my lord, no specific role played by the petitioner.
But
under the
charge sheet has been filed now.
Yes, my lord. Under
How
the
technically, how to get out of it? Tell me.
technically, my lord, yeah,
I have tried something. Just
they have cited the I have cited, my lord, that the petitioner was present at the time of occurrence, my lord. By the time
he was only present.
Yes, my lord.
Only present.
Only
What is the overtake attribute?
no overtake, my lord. No specific.
Let us see
no
the charge
overtake.
sheet.
Nothing is
Let us
there.
see the charge sheet.
Yes,
Now,
my lord.
on that ground, I will let us see.
Charge sheet is under Annex 2, my lord.
Let us see.
The brief fact of the charge sheet is page 34, my lord. 34, my lord.
Yes. Let us come. What is your name?
Chandrasekhar Senapati.
Huh?
Chandrasekhar Senapati.
Chandrasekhar Senapati. Just see. Find out the right sentence which can be used for discharging you. Sabyasachi Satpathy. Your name is Senapati.
Chandrasekhar Senapati, my lord. He was the
Rajguru Parikh, the group of agitators, group of agitators in Orissa Suraksha Sena, numbering about 19 numbers.
My lord.
Public megaphone, delivering provocation and abusive word against IIH. Acha, you are said they will not leave.
That allegation against other person, my lord.
Preventing you enter inside the. Where is his name?
In last, my lord. Page 35. Page 35. FR named accused person, including juvenile Chandrasekhar Senapati.
What is this? What is the role attributed to him?
No role.
And there are two leaders. See, there are two leaders, Sabyasachi Satpathy and Rajkishore Parikh.
Yes.
And 19 others.
19 others.
In that 19 others, you have put his name. What is the role ascribed to him?
True case under section so and so against all the FIR name.
What is the role? 161. See, 161 statement. Just. Do you have anything?
Yes, my lord. Someone.
Read it. Anybody has said anything about you?
Nobody has stated, my lord.
See, nobody stated means you have not filed anything, nobody stated. It is and the charge sheet, the reading, I have Mr. Mishra and counsel for the petitioner has taken me to the allegation made in the charge sheet and extensively read out all the statement recorded by the police under 161 CRPC. It appears from the evidence collected by the police and that it is and under the leadership of one or leadership of Sabyasachi Satpathy and Rajkishore Parikh, a group of persons consisting of 19 have given slogan against the IIC Dargah Bazaar. No specific overtake has been attributed against the present petitioner by any of the witnesses whose statement have been recorded under 161 PC. Even in the charge sheet, nothing is attributed specifically against the present petitioner. However, it is germinating from the record that the present petitioner was a juvenile at the time of incident, and time of the incident. The offences for which the petitioner and other accused persons are charged are bailable offences. Huh? Bailable offences. Have you checked it?
Yes, ma'am.
Yes or no?
Yes. Punishment is 6 months.
Bailable offences. And Mr. Mishra, I put it on you. Mr. Mishra, let counsel for this. Petitioner submit that the offences for which the charge sheet has been filed against the petitioner and other accused are bailable offences and maximum sentence prescribed for said offences at 6 months. 6 months. 6 months. Mr. Vishwal and counsel for the state, on the contrary, submits that this is not the appropriate stage for giving indulgence to the petitioner. Charge sheet has been filed. And allegation charge sheet has been filed in the present case, and the documents this court, while exercising jurisdiction under 482 CRPC, may not evaluate the evidence placed before the court, which form part of the charge sheet. However, the fact that the petitioner is a juvenile, however, he could not. The fact that the petitioner is a juvenile, because the same is reflecting in the charge sheet itself. I have carefully perused the statement of the witnesses recorded under section 161 CRPC and other related documents placed form part of the charge sheet. It is eminently clear from the records that no specific role is ascribed to the present petitioner. Even the witnesses have not taken the name of the petitioner, merely stating that Sabishachi, Barik and so and so were leading, and 19 persons have accompanied them. Will not make out a case against an individual who is neither arrested from the spot nor was apprehended immediately. In the present case, the petitioner was given notice under section 41C also, 41C, and therefore apparent that the petitioner was not apprehended from the spot. So, in view of the nature of the allegation and the material available on record, and the fact that the petitioner is a juvenile, nothing is attributed to him by the investigating officer in the investigation, I am inclined to allow the petition. Accordingly, the FIR and the charge sheet for the present petition is quashed.
Okay.
Yes.
C5.
I'm for the opposite party, madam.
Yes.
And Lordship, I wish to file some detailed affidavit. Lordship may take it no matter any other day, madam.
Sorry.
I will file some detailed affidavit.
Okay. So entered appearance for opposite party and seek an adjournment for filing detailed response to the petition. These the matter also interim order to continue. Yes.
Great.
6.
66, madam. I pray for adjournment, madam. On behalf of Mr. Panning time, my lord.
On behalf of Mr. On behalf of the counsel for the petitioner, an adjournment is sought on the personal ground. Please the matter. Yes. Yes.
May I please? The last occasion of lordship call we issue notice. For the lord.
Not common.
They can come.
Yes, there is not.
The counsel for the state submits that he has not obtained the case that he representative, and therefore he seeks 1 week time. Leaves the matter up to 1 week. Yes.
Lordship short date.
No, short date.
70.
Here, this is a case, I can recollect. In predicate, charge sheet has not been submitted. In a PMLA proceeding, date has been fixed to charge. I filed a discharge application, that application is rejected. My lord wanted to know whether the predicate offense case will stop till disposal of PMLA proceeding or not. Your lordship, kindly see the Sinthali Balaji case. para 21.
Until Balaji says that both the case should go together.
Para
That's all.
21.
It doesn't say that you have to hold.
And in any case, my lord, recently Honorable Supreme Court has stayed the PMLA proceeding. Same issue. That SLP, I have obtained the copy of the SLP. Kindly see this copy of the SLP. Same issue is pending before the Honorable Supreme Court. But Honorable Supreme Court has stayed the proceeding of the PMLA. In that case, my lord,
But what is last sentence saying?
Yes.
We make it clear that even if the charge is framed,
even the charge is
framed,
trial shall not be
the trial
proceed.
shall not commence.
Yes,
PMLA.
trial shall not proceed. That means when hearing shall not proceed.
Or the trial will not proceed.
Yes.
Now the charge has been framed against you.
No, in my case, my lord, discharge application has been rejected. I filed a petition to stop the my lord, further proceeding. That application has also been rejected. Against that, I have come.
Yes. SLP, yes.
The number of SLP is pending. SLP, I find the number of SLP is pending for on this point
What is
only.
the question of law?
What I suggest, my lord, may frame laws. Since this is a point of law,
No, in this SLP, the question of law is Vijay Madanlal. If
yes,
predicating
correct.
offense it is correct.
Correct. That, on the first occasion, my lord, I saw that para 109 of the General Chaudhary
That I've
case,
seen.
that my lord. Thereafter, my lord, Balaji case I have shown and Martin case, and this honorable court has also stayed the stop PMLA proceeding. Yes, yes.
The outcome of the trial, which is the schedule of offense, would determine the fate of the PMLA.
Court below should be advised to wait for the decision with respect to schedule offense.
It should be
Last 3 lines.
to ensure both the proceeding to continue simultaneously. However, the related court below should advise to wait the decision of court with respect to the schedule of offense before any pronouncement. Yes.
Court should be advised to.
What is the state the schedule of offense position?
Schedule offense will not have no instruction.
What do you say? Do you have any instruction?
Schedule offense. Charge sheet has not been submitted. I have given that. That is the entire case. Charge sheet has not
And
been.
you have to hold your hand.
Only my case is that if charge sheet has not been submitted, I will be this.
You have to hold your hands till the.
Yeah, charge is to charge. Why charge will be stayed? Your lordship, that last 3 lines of our own High Court. Trial court should wait till.
Trial shouldn't start. After charge, let it be.
Even trial goes, my lord. Because it has to go together. Unless that.
No, but all the judgment says that you should hold your hand.
Yes, my lord, one judge.
What is the hurry? You can wait.
Yes, let them file a short affidavit. Let it
Because
decide.
see, PMLA is contingent upon the outcome of that.
Trial,
So why can't you?
I can wait for trial, but why charge is to be stopped? Let charge be framed. Trial, your lordship says.
But he is challenging the discharge.
Your lordship.
On merits.
That's why I am playing. Your lordship kindly see this journey.
Then I'll issue a stay order and I'll hear it.
What I pray, my lord, let them file a short counter affidavit. My lord may decide.
Stay the trial, my lord, for the time being. Your lordship, but let the charge be framed. Because.
But I can't give a direction for you. He discharged, his application is moved. I can't give a direction that let the charge.
So kindly see why that order has been, how that order has been passed.
Then merit again I have to go into.
Yes, how that order has been passed. What illegality has been committed by the.
That is another facet of it. That is another facet on merit.
Because, my lord, Registration of FIR is sufficient to initiate.
It is vigilance case. Vigilance case?
Vigilance case FIR has been registered?
No. It's the schedule offense is vigilance case.
Yes, schedule offense.
Who is appearing for vigilance? Vigilance lawyer? Nobody is here.
Kindly see paragraph 29 of this judgment I do. S. Srinivasan.
Yes.
Legal position.
Para 20?
Para 29.
Yes. Yes.
At page 8. Section 2(1) defines proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a single offense, or the value of any such property, or where such property is taken or held outside the country than the property equivalent in value held within the country or abroad. Section 3, then para 30. Section
and I am not doubting that those things.
You also can see the what ultimate findings. Para 30 you also kindly see.
30?
32, next page.
Yes. Therefore, the mere position of
proceeds of crime is sufficient to invoke the provision.
you have rightly invoked. I am not saying that you have invoked it.
Yes, we have been.
Now the question is, will you hold your hand till the the PMLA is contingent upon the schedule schedule. So all the court says that wait till the schedule.
Vijay Madan Lal case, Hon'Ble apex offense under PMLA is separate and independent. So also kindly see Vijay Madan Lal.
Independent, I know that. There is no quarrel on those issues. What you are arguing, there is no quarrel. You can maintain a PMLA irrespective of that thing.
If charge is done, he is not going to be suffer anyway. Regarding trial, yes, I can understand your lordship may hear it. Your lordship may see this.
But today the question is, he moved an application for discharge, which has been rejected. He is questioning. The legality of that to be gone into in this proceeding. So therefore, I'll go into the legality and let you move an application for.
Question is regarding schedule offense disproportionate asset. That's a separate and independent. Here,
supposing you tell me one situation. Suppose you tell me one situation. If the vigilance officers will not file the charge sheet, file a closure report, what will happen?
That also has been considered in the Srinivasan judgment.
Serious Madras High Court. I am placing the Honorable Supreme Court.
No case is made out. Suppose what will happen?
Milord, that has been considered. That has been considered by the Madras High Court. They have said in this Vijay Madan Lal case, Milord.
Today you are justifying, complete 100% justifying the initiation of PMLA. No problem. But what he is saying is, see, charge sheet has not yet been filed. It may so happen, a closure report may.
Milord, I have to take because I have no instruction.
So therefore, I was wondering who is appearing. Can I take it after after lunch? I'll ask him to. We are speaking.
I will be pardoned, my lord. Mr. Maharana is on accommodation, my lord. This is CRLMC.
That 101 page.
Maharana is on accommodation, my lord.
Yes, we want to know in this case whether you have filed the charge sheet or not. What is the stage?
So he will, he will join on 24th. So let it be taken up next week so that he can join and he will answer.
25th. Put it on 25th. 25th. Mr. Maharana, let him come. 25th. Huh?
Mr. Maharana and Mr. Sangram Das both are appearing.
Tomorrow,
tomorrow he can file an
yes, that
Mr. Pradhan, let counsel for the petitioner submits that the matter is fixed for framing of charges tomorrow. Tomorrow. He may move an application for adjournment for tomorrow. Please the matter. You move application for tomorrow. Huh?
It is not fixed tomorrow. I know.
I have written tomorrow.
But tomorrow,
if it is there, it is there. It is not there. Not there.
It is not tomorrow. As far as my instruction, it is not tomorrow.
I have written Mr. Pradhan says. I wrote Mr. Pradhan.
There, my diary says it is not fixed tomorrow. I am appearing.
You are safe that prosecutor is not going tomorrow.
I am not going tomorrow. The matter is not fixed tomorrow.
But I have written if it is listed.
Tomorrow,
yes.
Item 72, Vigilance Council is appearing is not there tomorrow. Maybe adjourned a week after. Item 72.
Vigilance Council will come after lunch. Just see, Vigilance Council is waiting for you. Who is Mr. Marana? And 72, Mr. Das. Whether in the
It's
72
CRLMC
also Mr. Marana appears.
Mr. Maharana, CRLMC.
No, no, it's a revision.
Revision, Mr. Sangram Das will conduct. All the
Then let
revisions
him
conduct.
come. Immediately. Okay. Three.
Passing of the intercriminal proceeding on the
Yes.
ground that the victim was already married to the petitioner.
164 statement.
Sure.
Yes, sir. Yes, sir. Please.
Charge sheet has been filed, huh?
Well,
Foxo is there.
also is there.
Let's go.
What is the age of this boy? 23.
Marriage before the register of marriage.
What do you say? So is there, but see the allegation, he says that I have gone by his own free will. And the parents were trying to get her marriage. So since she was in relation.
And motorcycle, then they threatened for their consequences. Thereafter, they fled away. Both are well known to each other, and although they are released on bail, and charge sheet has already been filed.
How many accused are there?
Three accused persons are there in this case. Charge sheet has filed against 3 accused persons, and out of the 3, 1 has already been died. And 2 petitioners are before your lordship, and they are also present today, and informant is also present.
Yes, what do you say?
Allegation assaulted and take away rupees of 6,500 and broken the vehicle of the present informant. That is the allegation. Allegation. Page 24 of the.
Apart from the informant victim.
Yes.
What material do you have? The informant victim will not support the prosecution. What will you do?
That's right, Your Lordship, but for the more.
Why should they be put to trial?
Yes, that's right.
But he has now wriggled out. He is now supporting them. Then what evidence you have? Then even if I reject it, it is the exercise is completely futile exercise. Right? At the instance of opposite party number 2, FIR number so and so against the petitioner, allegation against the petitioner, so and so. Where are they? Deepak Kumar, Tarai, and Kirot Das. कौन कहले? Okay, भाई तो please. 52.
So only the matter is over, virtually, the matter has been argued at length 2.5 years after that FIR was filed against the IAC. The sub-inspector files against the IAC. And that's the last, just at the penultimate stage, my learned friend had submitted something like that on a specific issue that WhatsApp chats were seized. So your lordship said, why don't you reply to me?
I have already filed my WhatsApp chat by your phone.
That's
Yes, it's a WhatsApp chat. My submission is 2 lines, 3 lines submission. WhatsApp chat all determinative, there is no, and it was pre-incident. One. And secondly, WhatsApp chats also, if you'll actually go through, not determinative. And that was it, ultimately tested in evidence.
Either way, either for or against, it can be relied upon or denied or ignored at this stage. Whatever will happen that will happen at that stage. Ramifications on other materials.
No, you tell me the WhatsApp chat, whatever is placed on record, along with the charge sheet, it can be discarded at this stage.
Malas?
Can be discarded at this stage. Because you are challenging, you have come at the stage of cognizance. Cognizance. Can this court, while exercising 482, discard any piece of evidence relied upon by the prosecution by saying that it is admissible or it is not admissible?
No,
I can't go into. It may not be admissible, but the fact remains that there are.
I am not going there. I am going on your lordship's manner, the seventh ground in Bhajanlal's seventh ground.
Exception, whatever,
Yes.
exception. Malicious prosecution.
Malicious prosecution. 2.5 years after, he never discloses to anybody. These are the evidences I want your lordship to consider. Not that this should be the sole anchor for this issue.
I think
At the highest, if I'm making allowance for everything, at the highest, first of all, I strongly, under instruction, strongly denied anything like that happened. At the highest, if your lordship takes this also, WhatsApp chats also pre-incident into, at best, what else can it be but consent? I'm not also going there. I'm also not going there. 2.5 years. Sub-inspector of police never lodged in complaining, never lodged an FIR. Does not
no, those things you have already highlighted. She has given a complaint for women.
Yes, and this one comes in when the internal committee in post committee, they were holding against. All the evidences were against.
Which post are you holding now?
I'm IAC. I'm not getting promotion. I'm stuck.
What about she also?
I'm not. She must be an inspector.
What are you now?
She is working with the sub-inspector of police.
You are sub-inspector?
The DSP is clearly, she's in the habit of making false allegations against everybody.
Then Lawrence Senior is not finishing his appointment and saying that last 2.5 hours the matter is going. Last time.
No, I'm finished.
I was only thinking both of you are in a disciplinary post. And allegation, see, he has tried to make out a case of exception 7 of Bhajanlal. It apparently looks like. It looks like. Why don't you settle? I don't understand.
Mediation ko
He went to the mediation. There was quarreling.
Who has quarrelled?
I was not there.
You can't threaten me.
I was not there. I was not there.
This is the language of the client in the mediation.
Your service is at stake. Promotion is.
He has taken it for granted. This honorable court will cast it.
Why making this submission?
I'm saying about the mediation, but I am not saying about the mediation.
I'm strongly.
The mediation. No, I'm not saying about anything.
They may say whatever. Court has to take its own. That's
submissions.
And we had other people saying that WhatsApp chat. It's a WhatsApp chat.
I will hear it once again. Second week, entry mode to continue. I'll hear it first.
I was thinking, we give our notes and we close it. Whichever way your lordship decides, let us close this.
No, closing it's all right, but I have in the line lot of judgments. I will keep on, adding to my list. I want to exhaust all the judgment which are reserved. Thereafter, I'll start doing it.
One of my judgments was pending. Auto thing that Toyota Gaddy.
You have already filed the written.
Everything was there.
So many judgments are there. So therefore,
what has happened? If your lordship permits me, I'll do.
Yes.
By accident or whatever, the file has gone back to the listing side or to the section. It was reserved that your lordship will pass the judgment of our case. It was heard.
Give the number.
Then IAC was to say that whether he has arrested the other fellow or not. And only that. Our part was over. Your lordship said that no, there is absolutely no link on the. So by back to the.
Give the number.
Give the number,
I'll just put it in the second week.
Okay. Great.
Yes. Yes, sir.
This is a case for questioning of a criminal case pending between the husband and wife. They have settled their matter and accordingly mutual divorce already been allowed in the court of the family.
Yes, who is appearing?
My lord, appealing.
So if it, unless it is the internal communication, ଆପଣଙ୍କ ପାଖକୁ how?
What are the inventory has been prepared? What he has left? In one hand, he says that 71 lakhs of instruments are there. At the same time, he doesn't have money to pay the rent. What is this?
Not cooperating properly.
I'll quash it. If he's not comporting, I'll quash it. Finish.
Next page.
Yes.
General diary. Next page.
Yes. Stay the proceeding and I'll send it to mediation. Service is complete. If he doesn't come, then I'll watch.
All right.
That's the best way.
Yes.
Since I stayed the proceeding and service is complete, he has not come. I'll send it to High Court Mediation
Mediation,
Center.
yes.
If anything happens, otherwise I'll watch.
My
Right. Persons to the order dated 13/2/2025. Notice on the complainant has been served by the IAC Napoli PS, and in that regard, a report has been placed, which is taken on record.
And no coercive action against the petitioner because proceeding may be stayed, but otherwise on the FIR, no coercive action against the petitioner also.
Despite the service on the opposite party, he has not appeared before this court today. Apart from that, the counsel for the state has also placed on record the written instruction he has received from the IIC Napoli dated 18/2/2025, which reads as under. Regard being head to the aforementioned, I am for the considered review that the parties should be relegated to the High Court Mediation Center for exploring a possibility of a settlement. The mediation coordinator of Mediation Center shall fix a date and intimate to the parties for exploring the possibility of a settlement. Awaiting the settlement report, release the matter on so and so. In the meantime, no course of action shall be taken against the petitioner.
Give you.
72.
Madam, for 72 to 74, on behalf of Sangram Das, my lordship, kindly pass over. But right now, you just informed me that precipita for pass.
After the ask for passover, we say that it's midnight passover.
Yes, my lordship. Yes.
He doesn't want to face it. So what do you say? I'll put it.
Some of the date, but
27th. Okay. Put it.
well, like interim order may be passed because March and date achi. Time and again we are drawing the attention of the court.
Okay, so none appears for opposite party. Release the matter on certain Saturday. In the meantime, petitioner is at liberty to move application before the trial court. Gentlemen, if such application goes, send application. Move up.
75.
74.
73, 74.
73, my lord. Pleadings has already been completed.
I know, let him come. I will pass the same.
My lord.
I passed that interim order and list it. First week, second week. Seven. Huh? Yes, interim order will continue. Yes, 74 interim order to continue. No? On behalf of Mr. Sangram Das, a adjournment is sought. And adjourned also. Yes.
75.
May I please, Your Lordship?
Yes.
My Lordship, in this FAO, my Lordship, we have challenged the order of the Commissioner come Labour Commissioner, my Lordship. When my Lordship has, my Lordship, kindly have a glance to page number 24.
24.
Yes. The order of the learned court below.
Yes.
I am for the Clement matter.
Yes.
Yes, madam.
I am for the, I have filed this FAO, my
Yes.
Lordship, challenging the order.
You are the appellant.
Yes.
Yes. Yes.
Yes, my lord.
Compensation, the compensation was allowed to opposite party number 4, my Lordship, to provide the, kindly have a glance to page number 24, my
24. I'm there.
Yes. The claim application is allowed in part of the contest against the
You
opposite.
are reading the page 18?
No, my Lordship, page 24, the
Operating part.
Yes.
24. Okay.
Yes.
Yes.
The claim application is allowed in a part on contest against the opposite parties. The opposite party number 4, executive engineer, Teligiri, head work division, so and so, deposits sum of 14,69,369 in this court within 30 days from the date of this order for onward disbursement to the applicant. Filing with the opposite party number 4 shall be liable to pay 50% penalty along with 12% interest. Here, my Lordship, opposite party number 4 is a principal employer. Is a principal employer. So the liability also goes to the contractor, my Lordship, because my Lordship, kindly have a glance to that order, that document, neither the principal employer, neither the contractor, neither the deceased legal heir of the deceased workman have filed that he was working under the matter, my Lordship. Kindly have the glance to page number 18.
Contractor was a party?
Yes, my Lordship. Opposite party number 1, my Lordship.
1.
Yes. Simso Industries, my Lordship. But all the liabilities go to the principal employer. When my Lordship, kindly have a glance to the section 12.
12 of?
Employee Compensation Act.
Employee compensation. Employees compensation. Who is appearing for a contractor?
Somebody has appeared, my lord. He is not present today, my lord.
Service is complete on contract. Contractor.
He is contesting the case, my lord. He is appearing, my lord. In the last occasion, he has appeared.
Section 12, clause 2, my subsection 2.
Yes.
Where the principal is liable to pay the compensation under the section, he shall be entitled to be indemnified by the contractor.
Recovery?
Yes, my lord.
You have right to recovery.
No, that should be recovered from the contractor also. That part was not written in the order, my lordship. That should be written in the order. Because, my lordship, I have a judgment where it states that lordship, I have a true judgment.
I'll reserve your right to recover.
Yes, my lordship, but that should be reflected in the order. But the order was only the principal.
You are not concerned. You are interested in money.
See,
What she says that the right to recover should be there.
Yes, my lordship.
Yes.
But that was not written, my lordship.
Yes.
My lordship, can you have a glance to page 12 of the Bombay High Court judgment?
Bombay High Court?
Yes.
Yes. Aurangabad?
Yes.
Yes.
Page 12, my lordship. 16, my lordship.
Jointly and severally?
Yeah. Mr. Kothari, learned advocate. Appearing for the appellate attention of this court to the observation of this court in the case. So, Sarajio Unka Jagdev and Gurvinder Singh and others reported in 1990 MHLJ 790, particularly paragraph number 11 to contain.
Where are you reading from?
My lordship, page number 11.
11.
Yes.
Yes.
16, my lordship.
Yes. Yes.
Content that the statute has recognized three components independently, that is compensation, interest, and penalty. The fundamental liability of the employer is to deposit compensation within a 1 month from the date when it becomes due, add on a liability to pay the interest and penalty as the consequence of the default of the failure of discharge liability. It is therefore clear that for failure to comply with statutory obligations on the part of the employee, he can be saddled with the additional liability to pay the interest and penalty. However, the principal employer who is made liable to pay the compensation by the extent arm under Section 12 of the Employee Compensation Act cannot be mulcted with the liability to pay the interest and the penalty.
Yes.
Such liability would remain on the employer only for his default. In that view of the matter, the third portion of the law will have to be regarded as a substantial one and will have to be answered in the negative. The order of the commissioner to the extent of imposing a penalty and the interest of the appellant deserve to be quashed and set aside. Paragraph 17, the result of the aforesaid decision led to the court partly allow and the appeal as under my lordship. In the order, my lordship, it also says that B, my lordship, 1, the appellant are held to entitle compensation amounts also.
Jointly and severally.
Yes.
Yes.
And another judgment also I have cited, my have given.
Yes.
That also, my lordship, I have marked that paragraph, that judgment, I think. I don't have that.
You have given both the judgments.
Yes, ma'am. In second judgment also,
You take it.
oh,
Take it.
it also says that my lordship kindly have a glance to para 5, my lordship.
Para 5, huh?
Yes, my lordship.
The only issue.
Yes, therefore, the only issue which remains to be answered is to effect that whether the commissioner has confirmed that the present appellant is entitled to be indemnified by the contractor or not. In judgment shows that the commissioner has failed to confirm such condition, which is mandatory because of the provision of subsection 2 of the Section 12 of the Act.
Yes.
In that, in view of such fact, the appellant needs to be partly allowed by modified only to the effect that it is appellant has to pay the compensation as per the award.
Yes.
That if the appellant has to pay the compensation as per the award, then it shall be entitled to be indemnified by the contractor. That is respondent number 2.
Yes. Yes.
And
What
the
is
judgment
my lord, no.
yes, section 12?
2, my lordship.
Yes. Yes.
Yes, my lord. May I submit one line, my lord? During cross-examination, the executive engineer mechanical, their evidence, my lord, I has stated during cross-examination that on 27 to 2016, the painting work was undertaken at the Chitrakonda Dam and it was executed by the OP number 1, my lord, contractor. Though it clearly proved that the work is going on and during working period and the incident took place, madam. Yes, madam.
My lordship, kindly have a glance to pay.
You are appearing for the contract.
Yes, madam.
Yes.
We have disputed the employment matter. The relationship between employee and employer.
Not,
but he is not our employer.
See,
No employer.
And those stand you take in the proceeding.
Yes, no, my lord. You have taken.
they have already filed the objection, but that was not taken into the consideration.
Because not taken into consideration.
Yes. And page 19, it was showing that they have only filed the FIR copy, written report, inquest report, postmortem report, final report. Nothing, my lordship. That was exhibited by the lower court, my lordship. Not a single page of his employment, my lordship.
Yes.
Nothing, my lordship.
Another thing, my lord. The accident taken place in the night. And there was no light, nothing, no work was done during the night, after evening.
And the agreement, they are saying that the agreement was neither the...
They have paid out of court 50,000. I have got the copy of the affidavit, my lord. So also the police investigation report, my lord.
Because of the police investigation...
local inquiry report, IAC copy of the IAC. Incident took place.
Maybe the incident took place in that but he is not the employee of the contractor or the employer.
And they have paid 50,000. I have got the copy of affidavit. Actually, also there in the bunch, my lord.
Then you prepare a written note and give. Then it needs to be heard.
And we have examined a co-worker, my lord. He has also
LCR has come. LCR has come. You have to refer. Do you have the copy of it?
We'll take it.
Take it, pen drive. You
Pen
take
drive,
it
we'll
to
take it.
pen drive. Yes. And then also the LCR, the case has already been received. And also a very good party may obtain the copy of LCR by in a pen drive, soft copy of LCR in a pen drive, and let them file the written note of submission, release the matter for final issue. Yes. Take pen drive, you in the pen drive, you take it and prepare it. Yes.
76.
Otherwise, I can dispose it up saying that the right to recovery, I reserve the right to recovery. Then you.
I will be sufferer.
Yes.
I will be sufferer.
Yes.
26.
Madam, there are two appeals. That is the appeal of 513 of 2023 and 529 of 23. First one is filed by the claimant.
Claimants.
Claim.
Yes.
The
What?
legal heirs of
What
the
for?
deceased
For enhancement.
for enhancement.
Yes.
And other one is filed by the insurance company, as they were set as party before the court bill. Short fact of the case is.
What? How much?
Our amount is 15,98,562.
Death case.
Including interest.
I'll dismiss both.
Yes, my lord, I was suggesting that the death case.
This is the.
I'll dismiss both.
My lord, kindly hear.
I'm coming, my.
They have been set, they appeared before the court below, did not take any stake. And they are now coming with the appeal that we have been set expert. How they are said, what is the procedure for calling them to the court? They were noticed. They appeared through a lawyer.
That is second matter.
Second matter.
Let us see the second matter first.
My.
Second matter first. Okay.
Matters,
Yes. Second matter
the
first.
appellant insurance company has filed this appeal challenging the ex parte judgment. Entire amount I have already deposited before the Learned Commission.
Yes.
Here, my lords, my only prayer to give me an opportunity of hearing.
Let us see. The service is affected. Why should I set aside?
Here, my lords, I have not been given opportunity.
Let us see whether
Here, my lords,
proper service was there.
Admitted service is there, my lords. I am not disputing.
Then
the service was there. In fact, the first time the applicants filed their case with the Deputy Labour Commissioner, Jajpur Road, my lords. That was 242 miles. Subsequently, that was filed in the year 2015. In 2021, that case record was transferred to the DLC Cuttack, my lords. It was renumbered. And after getting the first notice, we have engaged a lawyer, he had appeared. But subsequently, when this case was transferred, on receipt of notice from the Deputy Labour Commissioner, we had also engaged one lawyer.
In Cuttack.
In Cuttack, Ramani Ranjan Mahanti, but due to communication gap, he could not able to appear. And this resulted in this ex parte judgment. That
can't be a ground.
No, I am ready to pay the cost, because.
But a determination which has been done in his favor, I can't set aside that at this regulated stage.
At least one opportunity of hearing be given.
This is not. These are beneficiary legislations.
Yes, I know. At least
in a beneficiary legislation, you don't have a right as such. You have to be diligent enough to prosecute your case.
Since I have not appeared, not filed a written statement.
If there is no service, I can understand. Service, you engage the lawyer, it was transferred to Cuttack, again you engage the lawyers. If the lawyer is mistake or for whatever reason, if it is not there, not there. There is an award in his favor. Why should I set aside that?
Here, the crux of the case, admitted case of the applicant is that the deceased died being dashed by an unknown vehicle, and the accident was not caused by the vehicle insured by the appellant. It was not caused by the vehicle insured by the appellant, my lords.
When was the award passed?
Award was passed, my lords.
Yes, 2023.
2023.
10 years has passed.
10 years, my lords. In fact, they had adduced their evidence in the 2023 before the Deputy Labour Commissioner Cuttack. And if at all that claim application was there, it is because of the latches of the applicant. They did not adduce any evidence when the matter was pending with the DLC Jajpur Road. And though the matter was transferred to the DLC the commissioner for the DLC, Qatar, they adduced the evidence in the year 2023.
Yes.
In fact, the company has no liability because the cause of death of the deceased is by an unknown vehicle, not due to the use of the vehicle insured by the appellant insurance company. I have a judgment of the Honorable Supreme Court, my lord. In that case,
The finding is there is a valid insurance. Yes.
the
Valid
insurance is all right. Unless the vehicle in question is used and caused the accident, then the company liability of the company will flow, my lord.
Yes. Anything else?
I am not disputing the insurance of the vehicle, my lord. That is the reason my prayer is that at least one opportunity be given, my lord. I am ready to pay the cost because I am not challenging the service of notice.
Then how will you, if
At least one opportunity
an separate ex parte order was passed against you? Have you challenged that ex parte order?
No, this ex parte judgment.
Judgment is passed subsequently. Then you might have been proceeded.
Because after passing of the judgment, it came to my knowledge.
Then you should have, when you are proceeded ex parte, that order you should have, also you have not challenged.
No, because it was not within my knowledge, my lord. Because there was a communication.
I think I'll dismiss both. I'll dismiss both.
Penalty and penal interest is there, which is not, your lordship may kindly have a glance.
Yes.
If your lordship will see that they have filed the case in the year 2015 and adduced the evidence in the year 2023.
Where is penal interest part?
Penal interest, my lord, here, my lord, last page 18.
Yes.
Brief page 18. Ordering portion, my lord. Within 30 days from the date of order towards disbursement to the applicant, failing which the opposite party number 2 shall be able to pay 50% penalty with 12% interest.
You just see.
Penal interest may be waived.
Penalty and penal interest is there. And my lord, my only prayer, I am ready to pay the cost. At least 2 months.
Give
me one opportunity.
He's fair enough to say that penal interest. 15 lakhs, I will not announce. The penal interest I waive and both the petition are
This is the actually the verdict of the Honorable Supreme Court that the company is not liable to pay penalty or penal interest. In fact, this amount, which
had it been an individual, I would have interfered. The insurance company, and if you are not diligent enough, then you have to face it.
It is an organization, my lord.
Therefore, you should have been, see, while collecting money, the entire organization is after people. For insurance, for premium. While giving and you have all the problem.
Here, my lord, not giving. Actually, what is my prayer? I am not denying that I will not pay. Only opportunity of hearing be given.
But then that award has to go. I have to set aside.
Only 2
and
months.
10 years back, some accident has happened. Again, he has to suffer for another.
After 2 months, my lord.
No. Then he will be in trouble. When will he get?
I am ready to pay the cost. Entire amount is in deposit. Entire amount is in deposit, my lord. There is will be no hurdle in getting his compensation amount. Only my prayer is 2 months. Within 2 months, let it be concluded by the commissioner. Entire amount I have deposited, not that I have not deposited.
Put an end to it, unnecessary. Put an end to it. Okay, I'll give it. I'll just
Then your lordship allow me to file note of short note of argument.
Note of service. You want to do it. It is a beneficiary legislation. In one case, give something.
No, this is had it not been an expert judgment matters, I would not have.
No, if the service would not have been affected, then I would have set aside straight away.
No, I am not casting any.
That's the whole problem. You have chosen not to appear. Now what to do? And the principal employer has already contested it.
Yes.
It is a contesting the award.
Here, another aspect, my lord. There is not a single document except the admission claim of the complainant, applicant, and the evidence of the OPW1. Not a single scrap of paper has been filed to establish that the vehicle against which the claim has been made was involved or he was any way concerned with the case, the cause of death of the deceased. Not a single document.
Anyway, let us put an end to it.
They have not filed a single document, only bulk statements on the basis of which this finding has been arrived at.
Entire police paper.
Police paper, let me show me that this vehicle number is there in the police paper.
Okay.
Not wrong submission, your lordship may kindly see what the document they have filed. The UD case record, inquest report, number has been made, mentioned.
And there is a finding, detailed finding.
Not finding. About the not involvement of this vehicle, there is no finding. The commissioner has given a finding on the basis of the bulk statement.
Yes, next, 77.
My lord, item 77.
Yes, that I agree.
My lord, item 77, I am for the appellant. My lord, the conducting counsel is ill, my lord, kindly taken up one other. No, my lord, a day may be fixed, my lord, a day may be fixed. A day may be fixed. In that day, I will file my submission.
Overlap. Let us understand.
Yes.
1 minute. What do you want to say?
This was the case, my lord. In the incident taken as 21 match, in the Chennai match, the labor was died during course of employment match. Thereafter, the case was filed by the labor department of Tamil Nadu match. Thereafter, transferred to Odisha. Here, the judgment was passed. Thereafter, my lawyer.
When was the judgment? 24.
24 match.
24.
24, there are. It is a very big insurance also. Not about the.
But in the personal grounds, he is asking, I'll accommodate once, only once. As the last and final opportunity, on the request of counsel for the appellant, leaves the matter on so it's made clear that no further adjournment.
And this may be settled, my lord, in before the my lords. This may be settled. The amount may be settled because it has been averaged.
Why don't you settle? Just keep, madam.
This may be settled. Because the 16,30,000 is the 38,000 is the principal amount, but the compensation authority has clubbed together the interest part and formed the principal.
No.
That 33 lakhs and 21 lakhs. Thereafter 12%.
Why don't you think of settling it? You explore the possibility of settlement. Like the parties have also submits that they will explore the possibility of a settlement in this matter. You explore the possibility. Now I have recorded it. Explore the possibility of.
My lord, my lord, say.
Interest, jadi waive kari further
Yes, yes. Reduce down to 6% or something.
My lord, it is optimized.
Shall I do it 6%?
No, my lord, no. No, ma'am. Without.
Use as I'm giving last opportunity. Explore the possibility. Huh?
Okay. Yes, yes.
And date will be fixed. First week record there. First week. Yes.
79.
6 to 9% is generally.
Interest part was not there in the EC case, my lord.
Consider
my lord. I will satisfy my lord. I will.
May I please, your lordship? May I please, your lordship? Well, the appellant was the assistant engineer, my lord, at that time, convicted on the section.
You are referring?
Yes.
Ready?
No, I have not prepared the written note. In the miscase, I had prepared and it is available in the record.
Miscase what?
Miscase for stay of conviction. That was fine.
No, stay of conviction. Don't waste time.
No. It was filed. It was filed and it is available in the record.
Yes.
So only in the in this appeal that is to be just it is to be substituted. The details are there. In the miscase, I had submitted.
No.
So I will just prepare the written with the permission from my friend, my lord. This was earlier listed before Justice Hon'Ble Justice S.K. Shah. I have pressed the matters, my lord, because he had only 1 year to go and his daughter was married, my lord. The fact of this case is, my lord, he was the assistant engineer and the allegation is that he demanded a particular 12,000 rupees, my lord, for the purpose of signing a final bill. The work order was issued for execution of a road, my lord, which is a food for work. He has received some rice and some cash he had to receive, my lord. And it is stated that the final bill was prepared, but the bill and he was not signing the final bill on the pretext of demanding some bribe, my lord. Your lordship may kindly see this statement. This aspect, this was the prosecution case. at the stage of investigations. While coming to the court, my lord, he did not support the prosecution case, my lord. This petitioner was supported the prosecution case in the chief examinations, but in the cross examination, my lord did not support the prosecution case. Your lordship may kindly see the PW2. The note ଦେଇଛି ସେଥିରେ କହିଥିଲେ note ଦେବା ପାଇଁ note ର copy ଦେବା ପାଇଁ କହିଥିଲେ justice ସାହୁ କହିଲେ ଏଇଟା ଯଦି if this is the fact it will take only 5 minutes but unfortunately in the meantime 5 years have passed.
Yes.
Your lordship may kindly see which is the decoy witness minor, who is the informant in this case. 76 at page 76.
Yes.
At page 51 is the affair, my lord. If I will place the affair, you also get a bare idea about the case, my lord. 51 is the affair. मोर नाम नेगी किसान पिता मंगल किसान ग्राम सुआंड सो मु आम ग्रामर तुम हाई स्कूल रास्ता काम ब्लॉक तरफ नहीं अच्छी से बाबद मत वर्क ऑर्डर मिली उक्त रास्तार कमिटी 3,30,000 टंका अटे रास्ता काम या पूरा सरी मु से रास्ता काम बाबद ब्लॉक रु 1,92,717 1,30,000 चाउल पाई सारी लॉर्डशिप काइंडली से पाई सारी थिला से तरफ उक्त कमिटी फाइनाल मेजरमेंट जेई और चेक मेजरमेंट होई नाही मु जेई को फाइनाल मेजरमेंट पई कहिबारु से कहिले असिस्टेंट इंजीनियर द पिटिशन माइलर तांको फाइनाल मेजरमेंट पई मना करिसंती या परे मु 23/4/2004 के मल्लिक बाबू को देखा कले मल्लिक बाबू दी पिटिशनर मोर फाइनाल मेजरमेंट और चेक मेजरमेंट कहिबारु से मते कहिले तुमे मते आगरु किंतु पीसी देई ना मते 6% पीसी न देले मु तुमको फाइनाल चेक मेजरमेंट करबी नाही बोली कहिले मु बुधवार 3/3/2004 ब्लॉक पाई मल्लिक बाबू को देखा करी परसेंट बाबद 20,000 टंका दे पारि नाही कहिबारु से मो कथा जमा सुनिले नाही मु पुणी आज सकाळे ब्लॉक जाई मल्लिक बाबू को देखा करी 20,000 टंका दे पारि नाही कहिले ओ किछि टंका कमेबो कहिबारु से तांका दाबी टंका को 12,000 टंका को कमाई देले जेहेतु मोर ट्रक बालार पैसा देवाक बाकी अच्छी मुझे कथार 12,000 टंका लांच नेबाक राजी हेबारु से मते आसंता काली 5 दिन 2004 की सकाळे आसियो कहिले ओ टंका देला परे फाइनल मेजरमेंट और चेक मेजरमेंट कराई फाइनल बिल बाहर कर देबाक बोली कहिले एनु मु बाध्य होई इच्छा विरुद्ध रे आसंता काली कुआनमुंडा ब्लॉक रे असिस्टेंट इंजीनियर मल्लिक को तांकर 12,000 टंका लांच नेउथुवा काम फाइनल मेजरमेंट चेक मेजरमेंट और फाइनल बिल बाहर करबाक जाउछि This petitioner, this informant has been examined as a PW2. FR te ekatha kahile se PW2 as he has been examined as a PW2 at page 76.
Yes.
I need not, because this is a very short case one, I need not take your lordship to the chief examination. In the chief examination he has admitted, and in the cross examination, the interesting cross examination, he has denied everything and he has also explained. Page 80 again.
Yes.
He has also explained under what circumstances given this amount to the accused.
I have not.
I have not gone to the accused on 23/2/2014 and he has not demanded. He has not demanded any percentage of bribe from me on that date. It is a fact that I have not stated before the vigilance police that on 3/3/2004 I had
within 5-6 months you could you could gain over him.
No, my lord,
see, the first cross examination is on 13/12/2010.
No, my lord, he
was recalled on 16/7/2011. Till then he was okay.
That is why,
and thereafter he comes and narrates everything.
Probably my lord has got the point. Probably this is the only point which has hurt the trial court. That my chief ro सब कहि गेल पुणे से मना कर दो.
And even if he suffered cross examination, he was standing his statement. And once he recalled.
Yes.
And he goes.
No, not recall. Defer ହେଇଥିଲା.
Defer पर आइसला पर 5 मास भीतर एवरीथिंग हैज बीन डन
से कला पर काहे क्रॉस और सपोर्ट कला न आगी नो कन्विक्शन को मते जाना पड़ुची ताको ईगो को हट कर
नहीं आपण देखंतु आपण जो चीफ हेइतला चीफ पर क्रॉस भी हिची आपण 78 चलंतु
क्रॉस एग्जामिनेशन बाय दी
नो 78 पेज 78
पेज 78 again
क्रॉस एग्जामिनेशन पार्टली
किछ हां
पार्टली
यस योर लॉर्डशिप
ता पर डेफर हैला
योर लॉर्डशिप इज राइट
डेफर पर से आसी कि they supported you for reason you know that yes
your lordship
but evidence is evidence what to do
yes ma'am
yes
your lordship kindly see I have not gone to the assistant engineer on that.
Demand is doubted. He said no demand. Okay.
Your Lordship may kindly see. It is a fact that I have received the final bill. It is a fact that I have received the final payment of rupees 193,217 for the work undertaken by me through check on such and such that, and the bill has been prepared by the JE, signed by the accused person. This is also found by the prosecution. Prosecution investigation भी देखी जंदी जे तांको बिल इतार दिया सरची. This is not a exaggeration. This is not a change mind. Your Lordship, paragraph 5. It is say paragraph. It is a fact
that never demanded.
Yes.
And he has given you a certificate of a gentleman. Now everything. Yes. What else is there? Yes. Any Mr.
Your Lordship,
the complainant.
Any complainant is declared hostile. Your Lordship, no Sita Raman's case. It has been decided.
What are the other material you have?
Yes, overhearing witness. Your Lordship may kindly have a glance to page paragraph 10 of the finding by the trial court.
Where have you declared him hostile?
So
where have you declared him hostile?
Same paragraph 80, 78.
No, 78. No, just
78. I have declared
78.
7 para.
Half
78.
But then you okay.
Your Lordship got it.
Yes.
78.
Okay. Let him complete. Let him complete. Yes.
Your Lordship may kindly see page 82.
82.
Yes.
Yes.
The court page 81, my lord. Page 81, my lord. It is a fact. After 7 to 8 lines, my lord, it is a fact. Forcibly thrust the amount. But when I say recover ki presumption, recover presumption. They are also here. They are also he has explained. It is a fact that I have forcibly thrust the amount in the pocket, in the pant pocket of the accused. Your Lordship got it?
And went outside and given the signal.
And when shouted at me to take the amount, I went outside and gave signal to the outsiders who are present along with me in the said room agenda, and the witness Sri Mohanta was at the gate, to whom I gave sign, and that I along with the villagers.
Mohanta, just see this Mohanta state.
PW1, my lord. Then my lordship may kindly see last. Court doubt court
I have read that. To the court also, yes.
Yeah, court needs a clarification. I do not remember the date on which I got the final. I lost the affair with the vigilance police after payment of the final bill. Of course, after payment of the final bill.
Let us see the month of statement.
Yes, I was instigated by the JE to lodge the false affair. So, my lord, the face of this, my lord, whether he is a trusted witness or not trusted witness, my lord. But on the basis of this evidence, my lord, I was convicted and sentenced to undergo a for.
Where is Mohanta's statement? Any the other witnesses, those who accompanied you, accompanied the reading party.
They have said they have supported my lord, but
let us see.
PW1 is a overhearing witness. And the prosecution has my lord, during investigation, the investigation authority has seized the documents, which indicates that there was no cause of action for giving him bribe, because that document indicates that final payment was already made before this date, my lord. That document has been seized. I have signed the document, my lord, that the document was sealed by the prosecution, indicating that the amount was made much before that.
Yes.
Exhibit 11, my lord. Exhibit 11. Case record bearing number high stroke of 2003-4 of a Kumbhamunda block. This exhibit, this document is seized by them, by the prosecutions, indicating that the final bill was prepared made.
Exhibit?
Exhibit 11. And even if my lord, as your lordship was asking me, even if my lord, the witnesses who are present, this other witnesses, my lord, over here. And this final bill was paid in the month of February, my lord. Exhibit 11 will indicate that the payment final bill was already paid in the month of February, and in the March, my lord, I was demanding, my lord, for final measurement. Total the case is absurd.
Come to page 71.
Pardon?
71. PW1.
Yes, ma'am.
71 out of 5-6 lines. The raiding party, this witness is Das, Prasad Das, Jagannath Prasad Das.
Okay.
He was one of the members of the raiding party who has given the signal to the raiding party to come.
Yes, ma'am.
He was in the veranda. He says the raiding party member immediately rushed to the spot and challenged. Gave the pre-arranged signal to the raiding party. The raiding party member immediately rushed to the spot and challenged the accused to have taken the bribe from the complainant. The accused then told them that the complainant forcibly thrust the money in the
Yes.
pocket, in the backside pocket of the wearing pant, and the accused brought out the money from his pant pocket.
This is the chief.
That is supported by the same version.
Yes.
Yes.
And this is the chief itself.
Yes.
Not question of accepting voluntarily, thrusted. He thrust, my lord. And also, your lordship may kindly see cross sections at page 74.
74.
74, page 74.
Yes. Yes.
Ninth line, my lord. I heard some noise which was not so loud. The voice coming out of the room was not clearly audible. On the entrance of the room, there was a screen and curtain. It is a matter of a long time back. I cannot say what they were talking about inside the room. Demand was I heard the words Poisa Anicho, but I cannot say specifically who of the many people present in the room uttered this word Poisa Anicho.
Yeah.
So regarding this demand, regarding my acceptance, this is the evidence.
Yeah.
PW34. Also number 34.
PW34, my.
Yes, 3.
PW34 magisterial witness.
He also says page 84.
Yes, the accuser denied to
The
have
accused denied to have demanded and accepted the bribe,
and thereafter
and disclosed that the complainant forcibly gave the money to him.
Yes.
And then Deputy Vigilance also
the
took
money
both the
was
hands
recovered from his pocket of this, but I exactly do not remember how the money was recovered from his pant pocket.
Money was recovered from the pant pocket, but I exactly
do
not remember how the money was recovered.
Yes, man, in the
from the
criminal
pant
case.
pocket of the accused. And after the recovery of the money from the pant pocket of the accused, I compared the account so and so, so and so. This is PW. 3. Yes.
The payment had been made from 21.
And your lordship may kindly see page 86.
Yes.
The witness are the same witness.
Magisterial.
On 17 to 2000, the final bill was countersigned by the chairman Panchayat Samiti on 21 to 2004 that the payment was made to the complainant by check number so and so, dated so and so, and the complainant Negi Kisan received the final bill.
Para 7. The complainant has not disclosed before us.
Yes.
The time of preparation of that measurement and check measurement had already been done.
Yes.
And that he had already received the final.
Yes, yes. What is the cause of action to give him bribe?
PW?
PW 4. Para 14. 16. Yes. Paragraph of third line, for which I had no scope to go through the contents of Exhibit 11. Exhibit 11 those you don't can after detection of the seizure of file Exhibit 11, I handed over the charge of investigation not the particular Inspector Vigilance. I had no scope to go through the contents of Exhibit 11. Exhibit 11 indicates that payment was already made. I cannot say whether the final bill for the project that is the road work of the High School of Reliable was submitted on such and such day, wherein MB number so and so has been referred. This is all matter of records. If I have demanded that the final bill I will not sign unless you pay the amount, final bill was already paid, then there was no cause of action. And once the decoy witness said that there was no demand and I have not paid anything, and being instigated by the JE to a court question, he has answered being instigated by the JE, I have lost this affair. Even if a doubt arises in your lordship's mount, the principles of criminal law, my lord, that any benefit, any doubt, if arises, benefit of the doubt must be given to the accused. And when the informer himself come on oath, my lord, in the witness box that there was no demand and I have not paid, there was no justification for the trial court to convict me. And one defense witness was also examined.
Insofar as the PW 4 is concerned, he has supported the prosecution case. He is also one of the.
Yes, I have given a written argument. I have mentioned it. I am solving a copy on this.
Who is supported?
Yes.
Who is PW4?
PW4 is the PLO, PW5 is the IO. PW1 hearing witness, PW3 is the magistratal witness. PW2 is the complainant.
PW4 supports the prosecution.
4 is the PLO. Trap laying officer, PW5 is the IO.
Okay. 4 and 5 supports the case.
1, 3, 4, 5. And
but one doesn't support. One
doesn't support. Yes. One is over witness. He has narrated everything else, and the complainant in course of the preparation has stated everything else before them who were present, and They were government official witnesses. Why they will tell lies against another government official witness? Why? What led them to?
Your lordship will not explain why they are telling lie. Your lordship is to find out the truth from the case.
Yeah, trustworthiness of the witnesses.
The justification is not why they are telling lie.
How smoke
But
will
the-
come without fire? Unless and until there was an occasion. How? Why this person complained and lost the affair agency?
See, only smoke and fire doctrine will not work in a criminal jurisprudence.
My friend was. Is it
Beyond reasonable doubt, you have to prove the case.
Yes.
If there is a smoke, so therefore there must be fire. Therefore, you burn him. It's not the doctrine.
Your lordship,
in criminal jurisprudence,
if your lordship,
you have to prove the case beyond all reasonable doubt.
Exactly.
So therefore, see, two witnesses have supported. 4 and 5 has completely supported you, and others are dicey.
And to some extent, the complainant has been declared hostile.
And
to some extent, he has support. He has proved his FIR.
That you will argue. Let us see. Let him complete.
My lord, your lordship said that the benefit of doubt, your lordship when proved views are possible. It's also
That's what we are stuck. That's what we are stuck.
If your lordship hears the judgment, your lordship can.
And the date of the raid, the final bill was already cleared.
There was total amount of 3 lakhs or more.
1 month back. There was
Total amount was 3 lakhs or more. In the FIR itself, your lordship. And if your lordship hears the judgment fully, your
I'll
lordship
read that. I'll read, obviously.
Your lordship can visualize the actual fact of the case. And to this portion which supports the defense, and my learned senior friend is supporting the defense. If your lordship hears the judgment fully, your lordship can visualize and can ask either parties to refer to either prosecution or defense. ये जो मिड्स रु आमे कहूचु जोटा मु मते सपोर्ट करियो प्रोसिक्यूशन मु कहबी जोटा डिफेंस को सपोर्ट करियो योर लॉर्डशिप काइंडली हैव ए ग्लांस टू पेज 26 of the paper book.
Yes.
What has been discussed by the
let me see the 13. When the raid has taken place?
4-3-5-3 5-3 ट्रैप was 5-3-2004. May I pray before your lordship that the documents are not available in this paper book, my lord. Only 13 exhibits are there. So these documents, may I pray that the documents may be supplied from the TCR and your lordship will be able to refer those documents in course of their work.
Come to page 67. 313, question number 40. Read it. Read it.
Question number
40.
Yes.
40. Read it out.
असिस्टेंट इंजीनियर हिसाब से कुमार मुंडा ब्लॉक में ज्वाइन करी जेईसी शंकरसन छटिया 12/2/2004 फाइनल मेजरमेंट ऑफ रोड वर्क एग्जीक्यूटेड बाय कंप्लेनेंट सॉरी थिला मु
ଉକ୍ତ କାମକୁ ତାରିଖ ଏତିକିରେ ଚେକ୍ ମେଜରମେଣ୍ଟ କଲି। ତାପରେ 17/2/2004 ସୁଖରେ
ପେମେଣ୍ଟ କଲେ। ତାପରେ 21/2/2004 ତାରିଖରେ
ଚେୟାରମ୍ୟାନ କାଉଣ୍ଟର ସାଇନ୍ କଲେ।
ଏବେ ସେତେ ଦିନର ପ୍ରାପ୍ୟ 1,93,217 ଚେକ୍
ହିସାବରେ ନେଲେ।
ଯେଉଁ ତାର ନେଲେ ଯେହେତୁ ତାର ମୋର
କୌଣସି କାମ ପେଣ୍ଡିଂ 12,000 ଟଙ୍କା ଲାଞ୍ଚ ଦେବା କଥା ସମ୍ପୂର୍ଣ୍ଣ ମିଥ୍ୟା ଅଟେ।
ସାନ ଛତିଆ ଜେଇ ଜଏନ୍ କଲା ପରେ ଆମର ବହୁତ କମ୍ପ୍ଲେନ ହେଲା। ମୁଁ ତାଙ୍କୁ କହିବାରୁ ତାର ମୋ ସହିତ ଅପ୍ରିୟ ହେଲା।
ତତ୍କାଳୀନ କଲେକ୍ଟର ତାଙ୍କୁ ତାରିଖ ଏତିକିରେ
ଟ୍ରାନ୍ସଫର
କରିଦେଲେ।
ବିଲ୍ ର ଡିଡକ୍ସନ କରିଥିଲା ତାର
ତାରି ପୂର୍ବବଚନ କମ୍ପ୍ଲେନ ମୋ ନାଁରେ ମିଥ୍ୟା କେସ୍ କରିଛି। ମୁଁ ଇଞ୍ଜିନିୟର ସେକ୍ସନରେ yes, this is the difference. Yes, this is the difference. Yes, I got the idea about case. Now let us see the judgment now. How the trial court has dealt with this. Let us see the judgment.
Judgment paragraph 10, page 26.
Yes.
Your Lordship got paragraph 10.
Yes.
Before discussing the evidence on record, it is profitable to discuss some uncontroversial facts for better appreciation of the contentions raised by the learned counsels for the parties. There is no dispute that the accused was working as assistant engineer in Kuarmunda block and was a public servant on the date of occurrence. The complainant was entrusted with the construction work, that is improvement of road from Dumorzor High School to Rairebarna at an estimated cost of ₹30,000. The complainant, after receipt of the work order, executed the road work and completed the same. The complainant had received cash of ₹1,92,717 and rice of ₹1,13,000
पूरा एटा नहीं
from the block.
पूरा जहाँ पाइबा कथा पूराटा पाइ जाइथिले।
The occurrence took place inside the Kuarmunda block. The tainted GC notes of ₹12,000 which the complainant produced at the time of preparation were recovered from the pant of pocket of the accused. Both the hand wash and pant pocket wash of the accused contained phenolphthalein powder.
That is
The accused was entrusted with the duty of supervising the road work executed by the complainant to check measure the same after the measurement of the road to be done by the JE. Now, in the backdrop of aforesaid undisputed facts, the evidence adduced by the prosecution is required to be scanned on the touchstone of the law laid down by the Hon'Ble Apex Court in the case of Ramcharan versus State.
Just forget it.
Wherein the Hon'Ble Apex Court in paragraph 23 of the said judgment laid down the following principles of law.
Come to para 14.
Para 14. The PW1 accompanying witness in his examination in chief categorically stated that the Deputy Superintendent of Police Vigilance introduced the complainant Negi Kisan to them. Whereafter, the complainant alleged that the accused demanded bribe of ₹12,000 from him to pass his bill. So saying, he produced 24 numbers of GC notes of ₹500 each. Sri D.K. Panda noted down the numbers of those GC notes on a sheet of paper and kept that paper with him. A vigilance staff brought sodium carbonate solution and chemical powder. When Sri Porida dipped his finger in a portion of that solution, the color of the same did not change, but when he dipped his finger in another portion of that solution, after touching the chemical powder, the color of the solution turned to pink. The solution were kept in 2 bottles separately, being duly labeled and sealed. The said vigilance staff also smeared the chemical powder on the GC notes and kept the same in
Yes,
the
I read it 14. But where is the cross-examination? Where has he dealt with the cross-examination?
PW1. PW1. It has been discussed in the subsequent paragraphs.
But he has taken the examination chief. Cross-examination, what he has said?
A cross-examination discussed.
Where?
Paragraph 18.
18. Let us see.
Page 32.
for 18.
First, your lordship may kindly refer to page 31. Middle person, the PW1 was cross-examined. Your lordship got it.
Page?
Page 31.
Yeah.
Middle.
Just with the permission from my client, my lord, page 31 middle, my lord, whatever the witness of statutory report, he has to analyze, my lord. He has said, surprisingly,
Just a
minute, surprisingly, on the next day, PW1 and 2 were cross-examined by the defense. Both of them narrated different story. And it was
Yes.
prosecution case.
Yeah, I will read.
If this is the story, my lord, the PW1 tactfully managed to rejoin his previous statement, but the PW2 directly supported the defense plea and deposed against the prosecution.
Page 31.
Tactfully,
Last
cunningly.
page 31, last one.
The client has to go with the evidence collected by him, recorded by him, tactfully, cunningly.
Page 31, last one, fifth line.
Yes.
The evidence of PW1, 3 and 4 regarding demand of bribe by the accused as stated by the complainant at the time of preparation is admissible in evidence and under the principal restriction under section 6 of the Evidence Act. The PW3 who was cross-examined at length was not at all suggested that the complainant did not make any allegation at the time of preparation regarding demand of bribe by the accused. It is clearly established from the oral evidence of PW1, 2, 4 that the accused had demanded a bribe of rupees 12,000. Next paragraph. It is forcibly contended by the learned defense counsel that the evidence of PW1 regarding demand of bribe by the accused cannot be believed in view of its evidence in para 6 of the cross-examination. He submitted that in para 6 of the cross-examination PW1, he has stated he heard some noise which was not.
Suppose you take out the evidence of PW3, the informant.
PW2.
So PW2, you take out because he has not supported you. You take out.
No, to some extent he has supported. He has proved his FIR. And as per the decision of the apex court, the hostile witness evidence cannot be thrown out.
That's right. That's right. Now, what I'm just trying to just put it like this. If the informant evidence is discounted, what else do you have to prove the
demand?
Acceptance, you have enough material. All the witnesses have said you can say. Where is the demand? If demand is only made to the informant. If the informant evidence is discounted for any reason, we'll just check it up whether it should be discounted or not. Then demand part goes. If demand part goes, it's sine qua non for conviction.
How
so now concentrate on demand part.
Yes. If demand is not made,
demand evidence. You have not laid any evidence in so far demand is concerned, except the informant.
No.
Who else is there? In whose presence was made?
Demand was made, the complainant himself.
So therefore, if the complainant evidence is discounted, completely taken out of the record, what else do you have to support the demand story?
So he is the best witness.
That's right. What? Just for the time being, you keep that evidence apart. And for demand, what else? You agree that for demand there is no other evidence except the complainant evidence?
Yes, PW13.
Yes.
PW13.
No, not that is for acceptance.
That is closed.
Acceptance. That's
maybe
acceptance.
But why did they tell about if there is no demand?
That's why did
first of all, my submission before lordship is that PW4 is the TLO. PW4 is the TLO.
PW1 has not supported.
There was no, if there was no demand, there was no question of trap. Number 2. Number 3, there was no question for making requisition to obtain the government official witnesses to the spot for preparation. Number 3. Number 4,
then if
number 4, when preparation was made, they have signed the
but independently you have to prove demand.
So if demand is not there, I will cite the decision, acceptance and recovery part.
You have to
Conviction has been made. Recent decision, 2024. I will cite that 24 decisions. Even if demand is not there, recovery and acceptance is proved. Conviction.
Section 20.
Conviction will
presumption. Section 20 presumption.
Yes, 20 comes into play. I will cite that decision. I had brought
that's the principle.
Yes. Your lordship might be knowing.
I have seen your lordship decision. Your lordship has also applied.
Yes, I dealt with that.
Yes.
So even if there is no demand, If, how and from where this amount was recovered and how turned to P?
Therefore, once it is recovered from him, presumption operate against him. That presumption is a rebuttable presumption. And in the reversion, 313 he says a story, and that is being proved, suggested to PW1, PW2, and also laid the defense evidence. So therefore, successfully rebutted the presumption.
Correct.
And this is the principle. This is the chain you have to follow. You have to lever there.
So I will satisfy your lordship in this way. Only 5 witnesses have been examined. One, according
I read all the evidence.
According to the trial court's findings, observations, discussions, etc., PW1, 3, 4, and 5. Except to some extent, PW3 was declared as hostile. Even if he has supported and he has proved his FIR, which cannot be disbelieved, he has convicted this act. So I will satisfy.
Let us see again the PW3.
Your lordship, kindly, different that your lordship kindly see page 34, 35, 34, 34. The findings, with these findings I will convict, of course. But
yes,
34, my lord, page 21. Roman 1.
Yes.
Of course, it appears from Exhibit 11. Your lordship was asking Exhibit 11. The case record of the project, the improvement of the road of Damanjodi High School, Raibena, road work in question was measured by the JE on such and such date and was that measurement of the accused engineer on such and such date and the measurement by
the complainant didn't know, therefore he paid. That's what he said.
There is no evidence on record to show that the fact was within the knowledge of the complainant.
Really?
How can he know?
So therefore he didn't know that. That is the reason he paid the price.
Exactly. From para 21.
That is what the para says. I am not.
Para 21 is the beginning. Your lordship may kindly.
But it was paid in the check. He received it out of the. He didn't know. This finding is.
Para 21.
Let us go by strict law. Now fact I understood. Let us go by fixed. See, for the purpose of demand, you only examine the informant. Okay, and for acceptance, there are many evidence. Those who have said supported, fully supported. Acceptance part is fully supported. Recovery is made. Recovery 100% made from
chemical examination report fully supported.
Everything is made. That you successfully prove. No problem. Therefore, the presumption operates against him. Now, the presumption under section 20 operates against him. Whether he successfully reverted it or not, that is the test.
That is to be seen.
That is the test. Yes. Let us labor on that. Why unnecessary going here and there?
Yes. That should be. That should be.
Lordship permits my lord. In fact, Lordship clinching the issue, saying that apart from the decoy, my lord, who are the other witnesses, my lord? Or some light pertaining to the fact of
so
because that's a sign corner. Lordship is correct, my lord.
If he could successfully see for reversion, what he has to do?
Correct.
Reversion, he has to do 3 things. First of all, he has to create a doubt while cross-examining the witnesses. On the basis of that, he can revert his presumption, which is operating against him. Second is, in 313 statement, he has to put forth the story, put forth his defense.
Defense plea.
And which is, he has put prosecution witnesses. Okay. Thereafter, he has to successfully lead defense evidence to disprove it. These are the 3 ways he can, revert this thing.
Agreed.
Let us see whether these 3 things has been done or not.
I will not say, in fact, since a lot you laid down the guidelines.
Very simple.
See, judgment has been reported in the last part, journal. Mr. Associate Mr. Review has argued the lordship judgment, if demand is not there, only acceptance, there is no condition can lie.
It is a sine qua non. Yes.
Last month.
So therefore, let us see.
But I will satisfy your lordship that acceptance, recovery, implementation, etc.
Parted, and put it. Exhibit.
All the exhibits are there.
Pen. Yes, you can take and give him pen drive.
Only 13 exhibits are there.
I have put login with beta. I have put login. Parted, okay.
Only 13 exhibits are there. Let it be treated as parted. I created this name may be, in the call list, name may be reflected.
And prepare a short note. You have to prepare a short note. Now you understood what is the conspectus.
In
Complete
the call
conspectus.
list, see that it has been terminated. My name may kindly be reflected in the call list. I will confirm.
Okay. 79.
79 and 84.
Sanjay Das, huh? Yes. Now whatever transpired, na,
Yes.
on that light you have to give it.
I will. Your also will stick to that only.
I will stick to that. I now understood the entire thing. I noted down and underline out.
Citations I will.
If Lordship permits, but may I
Aspect you also there.
in item,
You please give those this.
I have a submission, Lord. In item 72, 73, I asked my learned friend to pray for a pastor called in just the Mahapatra's courts, Lord, to argue another business matters in H2.
Then I have recorded that on your behalf a request is made. I have recorded that.
I'm deeply.
Yes, I have recorded that. Yes.
My lord, in the morning I have mentioned item number 72 of the.
1 minute, he is letting come. No, he will argue it. Argue it. Fix it. Huh? Second week.
Lordship is Lordship is correct. I agree to Lordship because Lordship laid down the guidelines, come up with another way, any witness throw any light regarding the fact of demand, bereft of.
That is,
now
we know where to now touch.
Bereft of decoy.
Instead of running here and there. Now, and the findings, the trial court is not happily worded.
No. He has observed, discussed everything else, but
disbelieved.
The cross-examination part, as well as he found out, he has not discussed vividly the cross-examination part. In order to support the prosecution case.
See, the witness is a part of the trick.
Exactly.
And he has done it. Why should you express in the judgment? You understand it.
That has been the main trick. After that, cross-examined after 8 months, he has been get over.
But can you write those things in the judgment? I am surprised. Why has he done all these things? Is not required. Wrong or right, whatever. The evidences are there. He has created a doubt. He has created a doubt. A doubt is a doubt. What to do?
He has proved his affair.
That is the reason he was put to cross examination. Doubt only. Yes, we'll see. Okay.
So it will come in the second week of March.
You prepare it and so that.
Second week of March.
Yes.
Second week of March. Second week of March.
Second
Second week of March, because we have not supplied with the steno or etc. I will have to prepare myself. Second week. That is the main difficulty.
Second week recovered date. 11th. Tuesday at 3:30. Indicated 3:30. So
You are visual.
substantially hurt. 3:30. 11.
Our side is almost complete.
No, only that part you have to highlight. The rebuttal part. Yes. Yes. Wanted to see something.
In the morning I have mentioned.
Which matter?
22 of the weekly taken up because this is parallel.
Supplementary 80.
Weekly list matter of supplementary list.
No, that's right. But every case has its own story. That's the whole problem.
Small matters will be affected.
Sir?
Small matters will be affected.
A small matter. See.
80 will be added to the weekly hearing.
No,
I have
weekly-
79. 80 will be added to the weekly hearing.
No, let it come in some other day if my learning changes.
It is also a draft case.
80
I'm
weekly.
getting
And now 79 80. His matter and his matter. I have appointed him as amicus curiae. 3 matters were there. 1 matter has already been heard. Out of 2 matters, he is appearing as amicus curiae. You are appearing on that. That matter has to be supplementary. 12 तारीख को 76. बार करेंगे और सारा मैटर भी धरी पड़े सप्लीमेंट्री नहीं आउट आगे पाके चीते आगे मैटर भी धरी पड़े we will adjust take you sir you will take 2 minutes but the other side is 2 minutes 4 minutes I'll take 4 hours
If a lordship permits me not, if a lordship permits me not,
because I have to read everything and write the judgment.
if a lordship permits, Justice M.N. Das used to say once. Somebody said like 2 minutes. Is it Maggie or case?
Same thing is happening. And you give your number, we'll see. I'm police the key we will adjust the date. Okay.
Item 86.
Yes.
Supplementary, third week, fourth week.
We'll see how will you adjust. Don't yes. Yes, Mr.
Next container, today I'm having the note of our weekly 72. My learned friend is mentioning it. Today I'm having the detail note.
No, you keep it, I'll hear it. Oh, I'll fix a date and hear it, finish it up.
Solve copy on the let him solve also a copy on.
Exchange it, I'll hear. Yes.
Item 86, my lord, weekly list. I pray let it come on supplement.
Monday. 25th. 25th. 72, huh?
76.
You 72, 76 weekly list is talking about. 76 you are talking about? In the weekly list. In the weekly list. I understand both of you are appearing in the same matter. Yes. Oh, there you go. Position. Any mention? You, Mr. Pradhan wanted to mention.
Item 86.
90? Oh, sir, many matters. No, 80 matters are listed today. Huh? 80 matters is
I pray only direction will given to the registry at my cost. I will report it cost.
Nowadays you take a pen drive and do it unnecessary. Record this paper. Weekly 95 order.
Item
79, 80 also.
Same order. See, if you go for paper book, it will come after 2-3 years. I'll tell you. The registry will not do it and it will be like this only. Better if you want to argue, take in pen drive, prepare paper book, give it to them. They are also handicapped. But give it to them, prepare paper book, give it to them so that they can assist and finish it up.
Item 86.
Supplementary list, I will see. I'll call him and
86, my lord.
I'll just